All right, welcome everyone. And Nancy, can I please hand it to you to kick us off?
I would be delighted. So I just want to say I'm delighted to welcome all of you to this program on ODR and family law in Texas and beyond. And I want to thank my wonderful colleague, Colin Rule. We'll be saying a little bit more in terms of introductions, but he is the one who really led us in developing this program and in developing the issue of family court review that dealt with online dispute resolution in the family law area. I'm proud to say he's a practitioner in residence here at Texas A&M University School of Law. He's going to be teaching a course on online dispute resolution to our students in the spring semester. I also want to thank all of the presenters, as well as Mediate.com, the Association of Family and Conciliation Courts, and Wiley Publishing for their help in putting together the program, publicizing it, co-sponsoring it. This is an important collaborative effort by all of us. And I want to make sure everyone knows that Wiley is very graciously permitting all of you to have free access to the articles that will be the focus of discussion. That is unusual. And that free access is available, I think, until the end of December. That's my recollection. There's more information about it on the webpage regarding this program. So now I'm going to say a little bit about the dispute resolution program at Texas A&M. In part, I'm doing that because I was at a program recently and there was a lot of discussion about what is it that lawyers are being introduced to in law school. Well, lawyers to be, what are they being introduced to in law school in terms of dispute resolution? And, you know, one of the things that we like to say here is that dispute resolution isn't just a topic we cover, but it's actually foundational for us. Our dispute resolution program has been ranked in the top 10 for the last 4 years, and we present programs like this one on a regular basis, and we also have an annual dispute resolution forum. Some of you might be interested in the one that's coming up. It will be March 1st. Symposium will be on the two faces of mediation, reasons for worry, reasons for hope. And we're going to have a wonderful group of people talking about that topic. So I mentioned that we make dispute resolution a regular part of the law school. And part of that is because we're unique in actually requiring all of our first year students to take a 1-week course on dispute resolutions, ADR survey. So every one of them is introduced to negotiation, mediation, arbitration, the role that lawyers play in those processes. And they also begin to be introduced to some of the new developments like online dispute resolution. We want them to know about these processes and the role that they will be playing, potentially as neutrals, but certainly as lawyers. And then we also offer a wide array of in-depth courses on negotiation, mediation, domestic and international arbitration. And the negotiation courses can be specialized, going from focused on oil and gas transactions to business transactions, et cetera. And then we also offer a concentration on dispute resolution for our students. We also have a deep bench of faculty who teach in these areas, teach and write in these areas, folks who focus on dispute resolution and criminal law. So looking at plea bargaining, as well as things like deferred prosecution agreements that the Department of Justice enters into with corporations. Arbitration in the workplace and mediation in the workplace, as well as dispute resolution and race, the intersection between those issues, international investment treaty arbitration. And I focus primarily on the intersection between dispute resolution and the courts. We also have, in addition to Colin, we have several other experienced mediators, arbitrators, and lawyers who teach courses for us in terms of the clinic. We have a tax dispute resolution clinic where the students negotiate with the IRS. And we also have adjunct faculty who coach competition teams. So as you can see, we do quite a lot here with dispute resolution. And if you have ideas for things that you would like to see us doing, please feel free to reach out. I will put my email address in the chat. I'd be interested in any thoughts you have on the sorts of efforts that are needed from law schools and educational institutions in order to be sure we're making appropriate use of these different dispute resolution processes. So now, with that, I am going to introduce Colin Rule and Richard Shannon, who are going to get us started. They'll be reflecting generally on the current and future use of ODR in family law and internationally. I have to say that it's a conversation between these two that actually played a big role in our decision to hold today's program. So today we're going to get a chance to listen in as the two of them, in a way, continue the conversation they began at that time. So I've already told you that Colin is practitioner-in-residence here. He also was co-editor of the Family Court Review's special issue devoted to ODR in family law. He's the president and CEO of Mediate.com. In 2011, he co-founded Modria.com, I assume an ODR company that many of us are familiar with. He's a real leader in the field of dispute resolution and ODR in particular, and Modria, I think, was really a model for many ODR providers. That was acquired by Tyler Technologies in 2017. And then for several years, Colin served as vice president of ODR at Tyler. Before that, he was director of online dispute resolution for eBay and PayPal. And he's worked in the dispute resolution field for more than 25 years as a mediator, trainer, consultant, and developer of these various ODR programs. He's been honored by the American Bar Association with the Frank Sander Award, and he's been honored by the Association for Conflict Resolution with its Mary Parker Follett Award. And there's so much more, but I feel like that's enough. Colin, you think that's enough?
More than enough. Yes. Thank you.
Richard Shannon, who I am probably occasionally going to call Rick Shannon. I hope you don't mind. I'm sorry, Richard, you are muted right now.
Look, my granddaughters call me Richie, and I give you that permission.
All right, thank you. So Richard Shannon has been practicing in the area of family law and conflict resolution in Texas for the past 25 years. He's been involved in coaching, counseling, negotiation, mediation. He's served both as a family law litigator and also as a mediator. And very importantly, I think for this discussion, he serves as the chair of the Innovations Work Group that was established by two of the sections of the Texas State Bar, the Collaborative Law section and the ADR section. And one of the things that I have noted that is on Richard's website is that he believes that family law courts, in addition to serving their traditional functions, should also facilitate the healing of human conflicts, which is especially important in the family law area. And consistent with that, he's the founder and president of the Enlightened Family Justice Institute, bringing justice and healing together. So with that, it is my honor to go ahead and turn the program over to Colin and Richard.
Thank you so much, Nancy, for that very, very gracious, maybe too generous introduction, but delighted to be here and delighted to be in conversation with my friend Richard. It's taking Herculean strength to not call you Richard, but I think that sounds like more appropriate for the granddaughters. But yes, I think the seed that turned into this event today is a conversation that Richard and I had at the AFCC meeting in Los Angeles, and we said, look, we should pull something together, and we reached out to Nancy, and it all came together. So I'm delighted that the day is finally here. We've got so many great things to cover today, but maybe I can ask you, Richard, to kick us off a little bit and give us an update about the state of the state in Texas, because you've got your finger on the pulse.
Well, thank you very much for inviting me, Colin. I'm pleased to present on this very important topic. Of course, the focus is online dispute resolution, and in particular with regard to family law. I would like to say that we might broaden the discussion, if the group is interested, into other areas outside of family law. The overarching concern that I have is how conflict that is normal and natural in all of our lives at every level, personal, group, political, how conflict might be resolved in ways that we would consider to be healthy rather than unhealthy. And by healthy, I mean healthy from the standpoint of individual and group psychology. What is the healthy way for us to handle conflict? Of course, the pandemic educated us that it's possible for conflicts, even those that are in the courthouse, to be handled online. Surprise. And of course, it's had transformative effects on the workplace with a vast increase in the number of people working remotely from home. So I think that it's very clear that there's a trend and a learning curve we're going through. The learning curve is that we can have effective communication and interaction even at a deep level of engagement using these online platforms. And of course, Colin, as we get into it, we'll talk about instances where it's going to be important to have face-to-face, in-person presence.
Absolutely.
Because there is a dimension that influences us, I think, intuitively and subconsciously, when we're in the physical presence of another person. There's, I don't know, I don't want to be, we might talk about energy fields, but there's something that's there, maybe difficult to describe, but I think we sense it.
I have a good friend who's a mediator who says it's pheromones.
Pheromones, well, that may be it. We do lose the sense of smell. Now, when it comes to conflict resolution, and I'm speaking now from the standpoint of the innovations team that I chair, which is hosted by the State Bar of Texas Collaborative Law Section. We do have on the team important representatives from the field of mediation, but and to be really clear, the ADR section of the State Bar is not an official host of this project. The project that we are engaged in is looking at the ways the private marketplace can provide non-adversarial processes that are far more effective and more efficient than conflict resolution provided through the court system. And we have looked at, right now, we're in the process of looking at over 30 different processes that might be brought to bear, available to help people resolve conflicts in all contexts, not only family law, which is very important because family law, at least in Texas, is over approximately about 60% of the civil law docket is made up of family law cases. But Nancy mentioned that, and this is, I think, a very progressive approach, the many fields of conflict resolution that are being studied at Texas A&M University, because I think it's important for us to look at all of those different fields and how conflict gets resolved. So the innovations team is taking a very broad look, focused on collaborative law, but all of these other processes that could aid collaborative law. One thing that I've noticed is that collaborative law and mediation are both movements, part of a movement that started, I don't know exactly when, but I would say somewhere around the 1990s, that come under the heading of therapeutic jurisprudence, preventative law, restorative justice, and so people who write on this have identified some 10 different tracks that have developed to help people understand healthy ways that conflict can be resolved. And these are all kind of coming together under the heading of integrative law. And so what I've noticed, my experience as a law student at the University of Texas School of Law, is that because the court system is structured from long historical tradition as a battleground that assumes the parties are adversarial and are in effect enemies. Lawyers are trained to serve as an advocate, and in effect, this becomes lawyers as warriors engaged in a game of word warfare. The trend that started, that's under this overall heading of integral law, therapeutic jurisprudence, preventative law, mediation, collaborative law, is a paradigm shift into lawyers as peacemakers and healers of human conflict. And in fact, healers of human conflict is a phrase that comes not from me, but from United States Supreme Court Chief Justice Warren Burger in the 1980s, which I think he was being descriptive. I think it's more aspirational. So I think that what we're looking at is how can we broaden and make more available these non-adversarial processes to the public. And I think that the technology, Colin, that you're taking a lead in online dispute resolution is very helpful for some very obvious reasons. It makes it possible for people who are very different locations to come together and have dialogue that is thinking together to solve problems. And as we know from the Harvard Negotiation Project, we want to think about problems not being the person, but problems are something separate from the people, even though we're engaged in it. So we're working together, but to solve problems. And of course, we like interest-based negotiation as a way to do that. So anyway, that's my perspective on this, and I'm ready to have a dialogue here with you, Colin.
Fantastic. Thank you so much, Richard. Yeah. Well, I'd like to show some slides, and maybe I'll go through that, and then we'll open it up, and you and I can have a conversation. We'll invite others to join us as well. Does that sound good?
Sounds great.
Great. And I do want to say thank you to Nancy and everybody at Texas A&M. I'm here on campus right now, and just everybody's so lovely. It's really wonderful to be as part of this community. But I also want to thank AFCC, because my good friend Melissa Kuczynski and I were given the opportunity to edit this special edition of the journal, and we had wonderful contributions from a wide variety of different fronts. I do urge you to check out Darren and Laura Kistemacher's articles if you get a chance, because I think it'll provide some additional color on the presentations they're going to be delivering. But let me share my screens here, because I do want to show you some actual hands-on. Let's see. Okay, so Richard, can you tell me, do you see a big screen there that says ODR.com? Is it working?
I see that.
Okay, excellent. So let me just talk a little bit, very briefly, about online dispute resolution, which is really about 25 years old. And we've used this definition to talk about ODR for a long time. It's just technology plus dispute resolution, really. So if you think about ADR, all the goals of ADR, the techniques of ADR, when we start to bring technology into the room, the virtual or the in-person room, that's what ODR is. So the goal of ODR and the goal of ADR are the same things. And when we decided to use the name ODR, we wanted to emphasize the commonality between the two techniques. Now, I will say this definition is getting a little long in the tooth, because it is quite broad. And there's so many different ways that people are utilizing technology in family mediation And this definition really doesn't get into the weeds. Now, the National Center for State Courts has done a lot of great work on ODR. I don't know how many of you are connected to court systems, but NCSC is kind of the big think tank for courts. And I was part of a working group. We came up with a new definition of ODR, which is, quote, a public-facing digital space in which parties can convene to resolve their dispute or case. And I like this definition. I think it emphasizes the facilitative, kind of the communication side of ODR. But one thing that it leaves out is actually what we call the fourth party. And I'm going to talk about that a little bit more, where technology can play more of a role in helping parties understand their options and actually helping them make good decisions. So I'm sort of leaning towards a new definition that brings in both the convening aspect and then also the decision support side of ODR. But the point I want to make is, and I think Richard alluded to this as well, the pandemic has really changed the game. And at Mediate.com, oh, I'm sorry.
Hey.
I'm going to mute you, Dildred. The line between ODR and ADR is getting very fuzzy. I mean, we've done surveys at Mediate.com that indicate that the majority of mediations are defaulting to online interaction. And I think the pandemic made people sort of comfortable with Zoom-based communication. And I have mediators that are really heroes of mine in terms of the work that they've done, who told me for decades, I just don't think I can do this online. You got to be in the room. It's what Richard was saying. You need to see the tapping foot. You need to be able to reassure your party by putting your hand on theirs when they get upset. Like, I just don't see how you can do this online. Well, the pandemic forced all of us online. And suddenly people started to realize, wait a minute, maybe there are ways to do this effectively. There are some benefits to having people sitting in their own houses with their cat on the lap, and being able to meet for 30 minutes and take a break, and everybody can go have a cup of tea, walk around the block, and then reconvene. So I think, technology is changing our society, and we have to meet our parties where they are. And I think as technology becomes normalized, we in the family dispute resolution field, we need to meet that change. So I think there's a lot of innovation that's happening. We don't have all the answers, but that's kind of what I want to talk about today. So another thing that Richard talked about, I think people think about often online versus offline or face-to-face. And I think that that's a false dichotomy. I think the way we live our lives is across a spectrum of online communication channels. And purely asynchronous, like just communicating over emails, well, that's one option, because you don't have to figure out scheduling. I send you an email and you open it up whenever you can, then you respond and I get it when I get it. But then you get into discussion board and chats, and then instant messaging, which is more synchronous text-based communication, and then the phone and audio conferencing, which is a very powerful form of ODR. It's not to be overlooked. And then you talk about video conferencing, which is just getting richer and richer as the bandwidth expands and the quality of our cameras get better. So when we are designing systems for our online family mediation processes, we need to think about this as a palette we can paint from. And when we need to fit the forum to the fuss, and that's not just about designing the dispute resolution side, it's also figuring out which of these communications channels are appropriate for the needs of our parties at each stage of the process. Richard, do you have something you wanted to say about that?
Yes, I think dispute systems design is a very important subject that needs further attention. And my perspective is that the piece that's missing today is dispute systems design. And that's under that heading comes, how do we come together? This is the communication piece. You're outlining here a spectrum of the various ways that can happen.
Right.
It's become increasingly obvious in a diverse society such as ours that it's difficult. It's very difficult for people to get together in the same room.
Absolutely.
And so nevertheless, some courts, at least in my local Central Texas jurisdiction, are insisting that parties show up for courtroom proceedings. And that poses a lot of problems for parties, and certainly for parties who have witnesses that are at distance. So it's very important that we, in a dispute system design, include how we're going to communicate, the mechanism we're going to communicate, and what kind of processes are we going to use to address the conflict we have.
Absolutely. 100%. One of the lenses that I appreciate, I want to thank the millennials and Gen Z for creating this lens, because I didn't really have it when I was coming up in the field, but it's this idea of privilege. Like, what privileges do people experience? And one of the privileges that I think is often overlooked is geographic privilege. Why is it that law firms buy offices right across from the courts? Well, because it makes it very convenient for them to head over there and, attend a hearing. But if you live 2 hours out of downtown and you've got to, take a huge chunk out of your day, take time off of work, dress in fancy clothes, drive all the way down there and pay $36 for, a half day of parking, that's a huge expense. And I personally believe that the courthouse of the future looks like this. This is the way people are going to access justice services in the future and mediation services. So we have to innovate using these tools. What technology is doing is it's putting more tools in our toolbox. So Richard is 100% right. If we're doing our dispute systems design, we have to use all the tools that are at our disposal to help our parties be at their best and to get a fast, fair, and effective resolution. And that means it would be irresponsible of us not to use these channels, especially if it can save our parties time, money, and convenience. And there's very interesting studies of family court services delivered over technology. And I think Darren can talk to this further. Some of these happened in Canada, but they show that satisfaction is actually higher with in-person services, in-person mediation, in-person court processes. But preference is off the charts for online. And it's because of the convenience factor. And if you look at other areas of the courts, there's a huge number of default judgments and things because people just can't show up. They can't take time off of work. They can't show up in person. So I think this is a way for us to open the doors of the process, of our processes, of the system. So
hey, Colin,
yeah, please.
Can I
Richard,
interject a second?
Yeah, definitely.
I wonder if it's feasible to create some criteria that makes it a little more objective when it would be appropriate to have in person versus to have another way of communicating. It's a
Absolutely.
And it seems to me that actually the way the trend is going, the dominant way of doing it is going to be using online, not
Yes.
in person. But if the shift becomes dominant online, then we may need criteria about when should we insist that people get together.
I 100% agree with you. One of the things we've been talking about at mediate.com is, do we need to integrate some information about online mediation into every mediation training? And my argument is not that we're urging everybody like cheerleaders to go use online. I think sometimes it's important to understand the dynamics of online communication so you know when not to use it. Because there are some circumstances where the use of online communication can exacerbate imbalances between the parties and create more problems. If you've got say you've got a husband and wife and they're divorcing and the husband works in tech and he types 100 words a minute and he's got gigabit Ethernet and he's, totally wired. And the wife is just not that comfortable with technology and she's just got a phone that's the only channel. Well, if you start to use online communication, you are tipping the playing field in a sense, tipping the conversation in the direction of the more tech savvy participant. And you may need to say, as a dispute systems designer, you know what? We're not going to use video conferencing. We're not going to use online document exchange. We're not going to use chats. We're going to use the phone because that's a technology that levels the playing field again. So I do think it's very important that we understand the dynamics of these things, not so that we use them more necessarily. It's that we use them better. We figure out which tool best meets the needs of our parties in each circumstance. So, all right, well, let me drive ahead and just do a couple more slides and I'll open it up, Richard, because I want to get your opinion about all of this. Now, as I say, ODR is ADR. It's just ADR plus technology. So a lot of the things that we do in ODR are very similar to what we talk about face-to-face and what we talk about in dispute systems design. Negotiation, mediation, it's very similar. Now, obviously, technology creates new possibilities and capabilities for mediators and technology-assisted negotiation. One of the things that technology can do is it can get you access to the parties much earlier in the life cycle of their case. So what we found, for instance, I did a big divorce and separation project in the Netherlands for the Dutch Legal Aid Board. And what we found is that the first thing that people do when the idea pops into their head, they have a fight in the kitchen and they go into their bedroom and say, I can't do this anymore. maybe I need to get a divorce. And the first thing they do is they go to Google and they type in divorce. Well, in the Netherlands, whatever divorce is in Dutch. And that's a very interesting moment because they're educating themselves about what does this process look like? What steps do I need to take? What education do I need to experience? And technology, as I say, if the phone is the point of access to justice, it's in people's pocket 24/7, and they can pick up the phone and they can type in divorce. And if your website is the first result that comes up in Google, you can help to play a role in diagnosing the situation and setting their expectations around the process. And that's an area in my face-to-face mediation practice, I rarely have that opportunity. By the time the parties reach me, they've already been negotiating, they've already reached a point of impasse and frustration. And that's why they reached out to a third party. So they're kind of at the end of the dispute for them, but that's the beginning for me as a face-to-face mediator. But online, I get access to disputes much earlier, even potentially in circumstances where the initiator has not even told the other party. So, you can start to have a conversation with someone that early in the process. And I think that's a very interesting opportunity for us as dispute resolvers to think about, well, what could we build at that problem diagnosis phase to essentially grease the skids toward resolution, towards a collaborative, a cooperative, and minimize some of the warfare that Richard was talking about. And the other thing is there's a lot of innovation around evaluation. It doesn't have to be only going in front of the judge. There's some very creative models around the world for providing evaluative feedback to parties, maybe non-binding evaluative feedback that they can take a look at, or even evaluating a component of their parenting plan or their divorce or separation instead of adjudicating the whole thing. And there was a great piece in the journal about that topic. So let me just charge ahead. I'm going to move a little bit faster here. The good news is online dispute resolution is gaining a lot of traction in the US courts. I think we've seen something like 70 or 80 courts launch online dispute resolution systems. Not all of them are for family, but a lot of them are. And there's a lot of learning that's happening, and these systems are improving. I know we have some friends from Canada. I think the British Columbian Civil Resolution Tribunal is maybe the most sophisticated online court in the world, but they're not doing family cases. But it's great to see all of this experimentation, and NCSC has a list. I'll give you their website in a bit of all of the courts. And then also there's so much happening around the world. I mean, we have participants from Mexico, we have participants from Scotland. We are seeing a rapid rise in the use of technology to expand access to justice and a lot of innovation in the family context. I mean, I'm currently building an ODR system for parenting plans in Ecuador. We're having conversations in Poland. As I said before, the Netherlands did a big project called the Rechtwijzer, which was very innovative. So it's great to see all this experimentation because it's just going to make ODR smarter and better and faster. So people have questions. What does this mean? What does this look like when the rubber hits the road? Nancy mentioned before, I ran a company called Modria, and Modria is now owned by Tyler Technologies, and they provide online dispute resolution courts across, well, really around the world, but mainly in North America. And they have a platform, this is a screenshot from the platform, that provides a very simple kind of TurboTax-like interface where the parties can come in and go through all the components of their parenting agreement and register their preferences in each of these areas: legal custody, vacation, transportation. And then the counterparty can also come in and they answer the same questions, and the platform indicates, okay, well, you've picked the same option in these areas. And that can be very helpful, again, for just a technology framework to go through these questions. Now, of course, a simple mechanism like this is not going to get resolution in 100% of issues. So after this, it can go to a mediator, but the mediator can then focus on the areas where agreement wasn't previously achieved. And even if you can't get agreement in 100% of areas through this online tool, you may get agreement in 6 out of the 8. And that can still, if you memorialize that agreement, that can be very helpful to the court should it go in front of a judge. So there's a lot of innovation that's happening right now around how you can use technology to support this. I'd also want to highlight in Australia, there's a very cool platform called Amica, which was built by a company called Portable for the Ministry of Justice in Australia. And they've done thousands of divorce and separation process through this very slick mobile optimized tool called Amica. And I urge you to check it out. You can go to the Amica website and you don't even have to have a real, you can go just try it out. But the platform is beautifully designed, and it goes through everything. It goes through money and property, it goes through co-parenting, it goes through visitation, and it's got a very, very clear interface that the parties walk through. They can make offers back and forth. It even integrates a little artificial intelligence, which I'm going to talk about in a minute. That's another really powerful platform that, again, was pioneered by the public sector in partnership with Portable, which is a user experience design firm. But in the US, there's also a lot of private innovation around divorce and separation. Some of you might have heard of It's Over Easy. Laura Wasser, the celebrity divorce attorney, started an online divorce process. And I think it was acquired by divorce.com. So divorce.com, I think, is the biggest player in this space. But there's others. Hello Divorce also is getting a lot of traction. I keep hearing about them in California. I know we had a friend from Idaho before. WeVorce, I think, is based out of Boise. But there's also Bliss Divorce. I mean, there are lots and lots of websites that are building kind of an online structured workbook type process. So you can see WeVorce has a 5-step process that settled more divorces than anyone else in the country. So, you know, my wife has said to me, it's so creepy that you build software to help people get divorced. And I said, well, you know, how do you think people find their spouses in the first place these days? I mean, it's all swiping left and swiping right and match.com. And, you know, the younger generation, pretty much there's an app for everything. So, you know, when you get to the end of your relationship, you say, look, I want to have a good divorce. I want to have I think as Gwyneth Paltrow called it, you know, the friendly divorce. And I think a lot of these platforms, that's what they're trying to do, is optimize the chance that can happen by creating sort of a streamlined process for tackling it. So the other thing that I just want to speak to briefly, and then we can open up for a broader conversation about this. In online dispute resolution, we have a concept of the fourth party. And I mentioned this in passing before, but it was originally created by Ethan Katch and Janet Rifkin back in 2000, 2001. So if you think about party one and party two, the divorcing couple as the disputants, and you think about the human mediator, or even the judge or court administrator, that's a third party. Well, technology is the fourth party. And I think a lot of people are worried about artificial intelligence because they feel like it's going to get rid of the mediators and technology is going to handle everything. I think we're a long way away from that. The third parties, the humans, are not going anywhere in the near term because there is a human psychological process that the parties have to go through with empathy and active listening and reframing. And the technology is not going to be very good at that. But there are a lot of things that technology is really good at that we ask it to do already in our processes, whether or not that's intake on our websites where people fill out forms or processing payments, administering cases, sending out notifications, managing documents, doing all the calendars and scheduling. I mean, many of us, Richard probably remembers back when you had to do it on the phone, call, hey, how about we do Wednesday at 1? Okay, that works. Well, we want to do Wednesday at 1. No, I can't do Wednesday at 1. How about Thursday at 2? And you just have the phone back and forth and back and forth. Well, now, you know, we go into technology, right in our calendar, you send an invite, people can suggest other times. So there's a lot of things that technology already does today. And this would have sounded like science fiction 20 years ago, but now it's just normal. It's just the way we don't even remember how it worked before we used technology for these things. But what I'm going to urge you to think about is kind of where these arrows are leading, because the technology, the fourth party is getting smarter all the time. And it can eventually, we may get to a point where it does research and it tells us, well, look, these are related cases to yours, and these are the outcomes that were achieved. You can evaluate our cases and tell us what the zone of potential agreement is. It can coach parties and give them advice and ask them questions. It can dynamically reframe content. So if one co-parent says something really aggressive or threatening or hostile, you could even have an AI pop up a message that says, hey, the other side might interpret this as kind of hostile. So we've redrafted it here and taken out some of the edge. Do you want to use this reframed comment, or do you want to use your original one? And they say, no, I want to use the reframed comment. And then helping people understand their badness, their best alternative to a negotiated agreement. Even enforcement. I mean, obviously, a big ODR platform is Our Family Wizard, some of which many of you know is a great platform for post-separation co-parenting management. And a lot of courts in high conflict divorces actually mandate the use of Our Family Wizard. And it has its own tools, tone tools, to try and ensure that the parties are not just yelling and threatening at each other through the tool. And then also drafting documents, submitting them to the courts. And then even potentially where we would just give all the information to an agent and the agent would go off and try and find a resolution and come back and ask us if it's acceptable. So some of these things may sound like science fiction now, but as I say, all the stuff on the prior slide sounded like science fiction 20 years ago. I'm guessing the technology is going to be doing all of these things. Maybe it's not going to take 20 years. Maybe it's 5 or 7 years. But again, the human is still essential in the process, but the fourth party is going to become more capable and competent. So the third party, the human, needs to learn how to partner with the fourth party. And we need to design our systems so they can evolve over time. So obviously it's powerful to have a fourth party say, look at similar cases to mine. What was the child support? What was the spousal support? And they can do that not just on one axis, they can do it on multiple axes. So they can look at lots of different variables and come out with sort of the sweet spot. But what I want to also show you, this is a platform called Next Level Mediation from my friend Bob Bergman. And I do urge you to check out the platform, but he's integrated artificial intelligence directly into his online mediation platform. So you can, at any point, and this is only the mediator, the parties don't interact with the AI, but the mediator at any point can say to the AI, hey, give me some questions that you think would be helpful to ask the parties in this case. And it'll generate all the questions. And again, you can say, none of these are good, or 2 of them are good. So you can check the checkbox next to the 2 that are valuable and ignore the other ones. But the AI is very good at generating ideas, asking questions. And again, the same thing, you can say, what are the key steps in a resolution plan? And the AI will step in and say, well, these are the different components. And you could say in a family case, what are the key components of a parenting plan that we need to put together? And then you can, memorialize those things, and through this platform, propose them to the parties. So there is a lot of work that's happening integrating in some of this fourth party artificial intelligence into platforms. And this is going to continue to accelerate. So I do urge you to pay attention to these developments. And if you can access ChatGPT or Google Bard or Claude, or even some of the new ones that are coming like Gemini, there is a lot of power that AI can bring. And I think it's going to play a greater role over time. So just got a couple more slides, and I'm going to open up, Richard, you can give some reactions. This is the ODR page from the National Center for State Courts. It's ncsc.org/ODR, and I'll put that in the chat as well. There's a lot of great resources on this page, particularly from the court perspective. And there's lots of examples of ODR around the country, particularly in family courts. And I think it's a great resource. And then there's also the ICODR, the International Council for Online Dispute Resolution, which promotes best practice standards for ODR around transparency and impartiality and confidentiality. Certainly using technology can create lots of potential ethical sand traps that mediators and dispute systems designers can slip into. So there is a lot of work in the field that's trying to think about what some of those ethical issues might be and how we can be proactive in minimizing the risks from them. So I just want to say all of this stuff is coming. My grandfather ran a lumber business in Dallas, and he always said to me, Colin, promise me, don't build your business where the highway is, build your business where the highway is going. And I think all of us should look at these trends and think, how can these tools help us be more effective in working with our parties, achieving the objectives that we have? So let me stop there, and Richard, let me ask you for some reactions and thoughts to all of that I just put out.
Okay, great. I think that you're absolutely correct about building where the highway is going to be located, not where it currently is. And there's a phenomenon known as cultural lag. So culture tends to, and cultural patterns tend to lag some 20 years or more behind movement in technology. So we're seeing paradigm shifts driven by the technological developments that you've outlined so well. When it comes to dispute resolution, we have developed outside of the courts important conflict resolution processes, mediation being one, and there are different models of mediation. Collaborative law, arbitration, and private judging to a limited extent is being used. However, there are other processes that can be brought to bear, and there can be mix and match combinations. So what this tells me is that what you mentioned earlier, let the form fit the fuss. What are the needs of the disputants. What do the disputants need in the way of facilitation to help them resolve their conflict? And that's why I think convening is a very important piece. And obviously, artificial intelligence and these technologies that you've referenced can be a significant aid in saving time and money in gathering data through questions, putting it into algorithms that process it to aid human facilitators to design processes, including ways of communicating, that help people effectively resolve their conflict, saving time and money. This is what I think the aspiration is. So one of the things I would suggest, Colin, is that in the earlier slide where you have mediation, I think it's now appropriate to say not alternative dispute resolution, but appropriate dispute resolution. What is the appropriate way for a dispute to be resolved? It might be in the courthouse, but it might also be that the parties are better served by a process out of the courthouse. And so we need to create smooth pathways for people to understand that litigation is not their only option, that they can have a legal process, but do much of the work outside of the courthouse, get their dispute resolved in ways that are save time, save money, and are, I would say, friendly to relationships. That is, helping people preserve mutual respect instead of being disrespectful, helping people build trust, and being compassionate. And in fact, ultimately, getting out of a fear-driven frame of mind into a frame of mind that is respectful, even loving of a party with whom you have a dispute.
Mm-hmm. Well, helping parties be at their best is a challenge. And, you know, Richard, one of the things you and I talked about is there are ways that technology can help parties be at their best, but there may be some other ways that technology hampers the ability for parties to be at their best. So can you tell me a little bit more? I mean, you have so much experience with this. I mean, what are some of your concerns about moving into an online environment? What are some of the ways that, you know, maybe the lack of, as you said, pheromones, being in the room, you know, really sensing the energy, it could really undermine the quality of connection between people. But what are your thoughts about that?
I think there could be situations where you would want, and I'm thinking mainly of divorce now, where you want the parties and the facilitators to be in the same room, at least for one meeting, to get on the same page with the spirit of the process you've chosen to work with, so that you have some familiarity. Now, I think that has to be balanced against the cost and other factors that are involved in bringing people together, because sometimes it just may not be feasible. The other thing I like about online is that it broadens the scope of providers that are available. Instead, you don't have to be local if you're online. I know of a dispute, a person that I work with who's in San Diego, and I think that person could be effective in working with me in Texas on a case if they have all of the qualifications. Another factor I would say about AI is that in the postmodern world, we're now concerned with a thing called cognitive bias. So the mental shortcuts that we use all the time to make decisions are called heuristics, and they're very effective. And if you have low stakes, where are we going to go to dinner? What movie are we going to go to? What type of, you know, those kinds of decisions have, you know, low risk, low emotional content usually. And so heuristics are appropriate. If you have a high stakes, highly emotional charged decision that's going to be made, as is often the case in family cases, what's my parenting relationship going to look like in the future with my children? Then we need to avoid heuristics and engage in critical thinking. And critical thinking means looking at our assumptions. It means identifying where cognitive bias might be present, such as anchoring or confirmation bias. And I think that AI could definitely play a role in helping people identify when some of those cognitive biases are present in our decision making.
Mhm.
So we want aid in to our decision making. It's always going to be human. We're always going to have subconscious components. We're always going to have intuition as well as thinking. We're always going to have emotions combined with thinking. But to get the best quality decisions, AI can definitely help us avoid some of these traps and pitfalls that are being identified by the folks that work on cognitive bias.
Well, I will say one of the hot topics we've had over Cyber Week this week has been the question of bias in artificial intelligence. And there are a lot of people that are worried. There's some great books. There's one called Automating Inequality, and there's another one called Weapons of Math Destruction. And it talks about how if you're going to train an artificial intelligence based on past data, and there's bias in that data that you're using to train the AI, well, you may end up replicating that bias and then
Absolutely.
actually expanding the injustice, because with technology, you can, extend that bias to many more people. Now, that said, there's a lot of research right now on how we can de-bias some of these algorithms. And I think that I think what you're saying, Richard, is really important one. Bias exists in the face-to-face world too. The concept of neutrality in mediation, there's a great book by a good friend of mine called Beyond Neutrality. And he said, look, this whole notion of being neutral, nobody is neutral. And when we say that we are neutral, we convince ourselves that we're neutral, we're actually hiding some of those biases within us that may be even implicit biases. We're not even aware of those biases in terms of the way that we act. So I think there are opportunities in utilizing AI and utilizing technology, maybe to watch humans and identify if there's anything biased that happens, but also have the humans watch the technology and make sure that the technology isn't doing things that are biased. So an interesting aspect of my online interaction is, as Nancy mentioned, I used to work at eBay and PayPal. And at eBay and PayPal, we never saw the faces of the people that we interacted with. We only communicate. We knew their usernames, we knew their reputation. But what that meant was there were fewer triggers for our bias to kick in with. Now, obviously, in family cases, that's not the case. When people walk in and sit down, immediately, as all humans, we start to make assumptions, and some of that's conscious and some of that's subconscious. But I think there is a possibility with artificial intelligence to monitor our processes. We know that people of color get 30% worse outcomes out of the courts than white people. That's been true for decades in the United States. And we've tried again and again to try and move that number. But it's a very difficult thing to do because, again, a lot of that bias lives in people's subconscious and it's implicit. But if maybe these tools will give us an opportunity to build systems. If someone comes to a website and they're going through a problem diagnosis process, that website doesn't know the race of that individual. That AI is not going to make assumptions based on appearance because it's not going to get that data. So hopefully there are ways that we can make the process fairer and increase trust. I could see in a generation or two that people would prefer that their cases in courts be evaluated by an algorithm as opposed to a person, because maybe those algorithms will get to the point where they've been debiased and people trust them for being fair and neutral. There was also a study that in Israel of parole hearings, and they found out that that's just looking at parole hearings over 6 years, and the people on the parole board are changing all the time. But the decisions rendered by the parole board were 25% harsher in the hour before lunch and the hour at the end of the day, as compared to first thing in the morning at 9 a.m. or right after lunch. Now, why is that? Well, people get hungry. And, it's like my mom always used to say to me when I was a kid, go eat something. You're fussy. Your blood sugar is low. That's one thing. And the other thing is decision fatigue. If you're asked to make the same decision over and over and over again, by the time you get to the 30th case, you're not thinking about it the same way as when you were deciding the first case. And there's something about computers. They don't get fussy. They don't have blood sugar. They can work 24/7 and they'll make the same decision over and over and over again, and they won't be influenced by those factors. So again, I'm not saying that it's better or worse. I think it's different. And I think that there are some of the shortcomings of technology that humans have to combat. And there's some of the shortcomings of humans that technology may help us to combat. So what do you think about that, Richard?
I think the ancient Greek philosophers referred to reason as a divine madness. Now, why would they say that? It's because we are not completely rational. And we humans are not completely rational, and we cannot get rid of the irrationality. So we're going to be partly logical, but partly irrational. If people go through a process, and this is what I like about these non-adversarial processes, if they feel heard, if they feel that they've been treated with respect, and they come to an agreement, even if that agreement is based on some irrationality, some cognitive bias,
right?
If they buy it, if they say this is workable for us, then it's more likely that it's going to be durable, and it's going to prevent conflicts in the future. So the problem comes when you have an authority figure that has bias and imposes a decision on parties, and they don't like it. Mm-hmm. Then they want to keep fighting because they resent it. So it's dealing with these emotions aided by AI. And of course, AI can help us say, oh, I see where my irrationality lies. But they're going to be personality types that they don't care. They're so disordered in their personality typology that they can't see it, don't want to see it, and you're stuck with that. Mm-hmm. And that's where we may need courts to impose decisions. Mm-hmm. So it depends on, I think there's a complexity analysis with what is the nature of the people who are in the dispute, how flexible are they in their thinking, what are the complexities, emotional complexities, and the emotional relational complexities, and then if it's a legal matter, what are the legal complexities, or if they're technical issues, what are the technical issues that need to be resolved. So if you have high complexity, then you probably have more need for facilitation. If there's low complexity, then I can see how some of these online platforms can help people get save time and money in getting a resolution.
Sure.
So I think that's where the convening piece is really important. What's the level of complexity? And therefore, what's the process best suited for that level of complexity?
Yeah, Richard, I put a link into the chat to a tool that I was involved in putting together called the MASIC, which is a screener for IPV, intimate partner violence. And I think one of the things that we have to get really good at is triaging different types of cases into appropriate resolution channels. So if you've got two young people and they got married, they don't have any kids, they don't have any shared assets, and they say, you know what, we don't want to be married anymore. That's great. I mean, most states, you could just fill out a form and file it with a court and you're good to go. You don't need to worry about child support. You don't need to worry about any of that.
Right.
But if you have people that have been married for a longer time and there's a pension and there's kids, then, that's a more complicated process. So just like we talk about the multi-door courthouse where we sort cases into different pathways, I think even within the family court or family mediation, we do need to get better at that sorting. And most of the systems I've been involved with for family mediation, they're collaborative processes, but you do need to do screenings. And one of the things you have to know is there a risk of violence in this case? Because that may mean this is not a collaborative process. One person, maybe one of the parties may be participating under duress, and you're not going to get a good resolution that way. So Amy Applegate, I was actually, Peter Salem from AFCC put me in touch with Amy, and she's been working on this mediator's assessment of safety issues and concerns for more than a decade, but it was a paper-based screener. So now we've turned it into an online platform, which is free for anyone to use, and it'll generate a full report based on the series of the short MASIC questions. But I do think we need to put into our processes, because it gets to exactly what you're saying. in terms of complexity of the case. And I think IPV is a factor that can say, you know what, this process, there are factors here. There's been protection orders. There's been accusations of child abuse. This is not the right fit for this collaborative, friendly process. We need to take this case out and put it into a different channel that's more appropriate for that kind of matter.
Right. So,
Yeah.
you know, other thing, Colin, is that AI can be an aid to the facilitators. And it's not just the disputants, but I can think of, to make it concrete, a CPA who is using AI and algorithms to aid with the difficult problem of collecting and analyzing data where there's questions of tracing to determine if property is separate or community, or tracing for hidden assets and fraud on the community. So you have issues like that where a facilitator, third party, CPA, uses AI to save the parties a lot of time and money by inputting the data and analyzing the data. But the key is the CPA has to, and this is where the human element is going to always be there, has to figure out the coding that's going to make the algorithms useful and not come up with skewed results.
Well, I do think there's a lot that AI can do. Mediators often say to me, you know, am I going to lose my job? Is AI going to take away my cases? And I say, I don't think that AI is going to take jobs away from mediators. As I say, the third party and the fourth party are both essential participants. But I do think that mediators with AI are going to take cases away from mediators without AI. Because just like you said in your example, the accountant that can use an AI to you know, bring in all the documents and quickly generate a return, that's going to be cheaper than the accountant that has to manually go through everything and put it all, you know, by hand into a spreadsheet. And over time, the consumers are going to say, well, I want the AI powered accountant. And I think that's true for mediators as well. These tools are becoming ubiquitous, and our parties are going to be using them every day in their work, in their lives. It's going to be, I mean, available for free in the search engines. It's going to be integrated into Microsoft Office. So if we can't utilize these tools, parties are going to look elsewhere because their expectation is that they'll be there. So
and going back to what Nancy is doing, we need to integrate all of this in the education that's being provided to lawyers and others, professionals that assist lawyers in resolving disputes. So it's very important that the curriculum in law schools and other professional schools be shifted to integrate into their curriculum all the benefits and aids that online dispute with online processes and artificial intelligence can bring to bear.
Absolutely. Absolutely. All right, well, we only have 12 minutes left before we're going to hand it to the next panel. But I wanted to see if people had any thoughts or questions or comments based on what Richard and I have been discussing. There's so much expertise in the room. Terry, I see your hands up. What did you want to say? Oh, I'm sorry, you're on mute.
I wanted to comment on a couple things. Richard's been talking a lot about creating more private, non-adversarial options for outside of the court system. And I think to truly reach that target market of these divorcing couples, we have to have those non-adversarial processes at least introduced at the courthouse. Because what I found in 30 years of mediating, that people don't always know about these options. And if they walk in the wrong doorway at the beginning of their divorce, they're in an adversarial proceeding because they didn't even know they had a choice.
Right.
And one of the things that I think is really exciting about ODR is I'm very interested in dispute system design and family law system reform. And I think that we can marry these two and do a really good job, because I think we're going to start seeing that we're going to have to bring reforms to the family law courts in the form of early dispute resolution. And I think what's happening is that these processes are getting introduced too late. So one of the things I'm looking at is doing that earlier. And so I totally agree with Richard that, you know, the problem is getting more people to use non-adversarial methods. So I think it's really exciting that's why I'm here at this forum, is I was really interested in, is ODR going to help with those reforms that I think are imminent? The other comment I just wanted to make, Colin, was I'm a little uncomfortable with calling technology a fourth party. I really look at it as a tool that the third party and the two individuals, at least in my case, because I do all divorce mediation,
Sure.
that it's more of a tool, and that we're going to manage that tool rather than elevate it to the status, of having its own personality, so to speak. So those were just a couple of my comments, but I'd like to hear if Richard has any thoughts on, reforming the actual court system rather than just saying, let's get more private options. What are his thoughts about that?
So look, Terry, I would appreciate it if you would send me an email at richard@shannonfamilylaw.com so that we could continue this conversation, because I think it's a very important one. And here's my response. Enlightened Family Justice Institute was set up as a nonprofit to work on getting courts to reform how they handle family law cases. What I learned from that experience and working at a high level with the Supreme Court's Office of Court Administration is that there are a number of factors that create a lot of resistance for courts to reform, even if judges want it. Consequently, I came to the conclusion that the courts are there and serve an important function in certain circumstances, but what's missing is what might be called the multi-door courthouse or pathways. And that gap can be filled, I think, by having several things. One, it's possible to have some training videos that parties are required to look at, but then there needs to be what I would call a convening element. Now, and it remains to be seen whether the courts would incorporate that as part of what they do, or if the convening element needs to be offline. But what needs to happen is, and I think the courts would be open to this, is creating what I would call an exit ramp off of the courthouse freeway, so that people know that there is an exit ramp. The convening process, though, is one in which somebody, and it can't be the parties, has to do this complexity analysis and then use that complexity analysis by gathering data, and AI can assist with the gathering of the data and analyzing it. Use that complexity analysis, say, okay, for you folks, this is what would be, we think, some good options for you to consider. If there are some 30-some processes, that's way too many for disputants to sort through and figure it out. And it's way too many for an attorney to run through in an intake where people, especially if people are having to pay for the intake. So I think we need to make it more efficient. We need this convening process to be developed and become more robust, so that somebody who knows all of the tools in the toolbox can then put together a design and say, this is what we would recommend for you folks. But it's your choice. You have a choice. You can go to the courthouse. The Constitution guarantees you the right to a trial if you really want it. Well, you need to consider the consequences of doing that. And here's some maybe better choices for you. And I think that's part of what we're developing through this innovation team, and we haven't finished our work yet.
Yeah, Richard, I will say a very good friend of mine recently got a divorce in Texas, and I said, I actually know a fair amount about this, and I don't want to talk to you about my divorce. I'm going to figure it out myself. And they were bewildered by all the choices. They went out and did a little research. They bought Texas Divorce Magazine and tried to educate themselves, but they did not know the difference between mediation, collaborative law, the traditional court process, right, and some of the attorneys that they were thinking about, I was looking at their ads and they were fuzzing up the terms. They were implying that they were going to be collaborative and they did mediation when in fact they offered the more traditional court-based,
Right.
warfare approach.
Right.
So I think I agree with you that we need to get better at making the choices clearer for the parties we work with. And let me just say, Terry, you did say one thing about the fourth party. I understand it could be a little creepy. I try to put that little happy icon of the robot there, it's not threatening. I think some people, when they hear AI, they think the Terminator movies, where it's Arnold Schwarzenegger robots, murdering all the people. So I think I like the fourth party. It's a little bit less threatening and it emphasizes the partnership. But I do understand it is a tool. Fundamentally, it's a tool. And when I do trainings on the use of AI in mediation, I often say it's like an intern. It's only going to do what you ask it to do. If you don't ask it to do anything, it's not even a role. It doesn't have a role. But if you ask it to do something, it will eagerly do it, but you have to review it because the intern doesn't get everything right all the time. But I agree with you fundamentally. I like that metaphor of it's just another tool in the toolbox. And we get to decide when to use it and when not to use it. And it does not have its own agenda. It does not get to make decisions. We get to make the decisions, and then we ask it to help us follow through on the decisions. Is that a little bit more satisfying?
Yeah, and I think in essence you said that. You use the word this tool,
yeah,
even after you identified it as the fourth party.
I'm just trying to put a smiley face on the hammer. That's so.
Yeah. Where do you practice, Terry?
I'm in Orange County, California. And, I'm also one last thing I'll say is I'm kind of upset with the total, just the way everybody's saying online, that's the better way. It's going online. It's always going to be online. I find the majority of my clients, if they have a choice, if geography isn't involved, it's always online. And especially it's always in person. And especially at an initial consult. They want to meet me. They don't want to put their family's lives in the hand of somebody on a screen. So I find that the online option is not favored in where I'm coming from, unless, like I said, somebody's in San Francisco or someone's in another state. So geographically is all I'm finding is where, online is so popular. So I'm still seeing a lot of traditional mediated cases.
Amen.
So, Terry, my response to that is that I think on the front end, initially, when you're first meeting and getting acquainted, having that personal presence is very important. It's very important in building trust, that this is a person that I have confidence, I can trust that they are being straight, they're being authentic, they understand my interest, and you build an empathy. But once that's been established and it's present in your mind and your spirit, then I think you can do a lot more with an online connection.
Well, they also want to see you.
But if it's feasible and people want it, sure.
Yeah.
Absolutely.
We should be client centric. What do the clients need, and how do we as providers and facilitators meet their needs? That's marketing 101.
I totally agree. Now, I do want to get to Darren's presentation. We got 3 hands up, and I want to go through all 3, and then we'll go to Darren. But David, I saw your hand first. So what did you want to say?
Yes. Hi. Thank you so much, both of you, for this fantastic presentation. So much to think about. I'm having conversations week in and week out with people who want mediation or collaborative law. And what I tell them is that my default nowadays is to do it by Zoom, whether they're local or they're in distant locations. And I tell them that that my reason is threefold. Number one, it's less expensive for everybody and it's more efficient. A lot of people I work with have very tight schedule. Number two, COVID risk. And number three, climate change. And I've said that my analysis of my personal climate impact is that it's mostly transportation. And that's what I think most professional services consulting firms have concluded. And so if I can reduce travel to the minimum that's needed, and I agree there are some cases that need to be in person. I've had 4 in-person mediations since the pandemic started, but only 4, which I think is kind of mind-boggling, at least to me. but the reason why I wanted to mention that third point about climate change is that I think that we all want to be moral actors, and I think that we can't avoid thinking about that, among other issues. So a default doesn't mean that I only meet via Zoom. But what I found is that for pretty much everybody I talk to, they say, well, that makes sense. Let's give it a try. And then they find, yeah, it actually works rather well. One last thing, I have found that managing aggression in a Zoom space works better than in personal space. And when I have one person who's a little more domineering than the other, or a lot more domineering, the ability to use breakout rooms and the mute button has been very helpful in creating more of a counteracting power imbalances.
Yeah, thank you, David. I will say one of the interesting dynamics that we've observed in some of the simulations we've done with Zoom-based mediations is, in face-to-face, my face-to-face mediations, there's often a lot of overtalk. One person's talking, you have to say, no, let's take turns. But one of the things that's interesting about Zoom is there's noise cancellation. So if two people talk at the same time, it cuts out. So you can't hear what anyone says. So in a sense, the technology becomes kind of your helper, because parties have learned in video-based communication, they can't overtalk. It's completely futile. So people have they take turns in video-based communication, and you don't, as a mediator, you don't have to say, okay, let's go one at a time, because obviously face-to-face, there's no cutting out. So there are some ways, again, and I think one of the things that I like about Zoom-based mediation is you can actually look at the face of the listener while someone else is talking, which I find is fascinating. When, if someone's saying something and you really want to know how it's being heard, in the room, it's very difficult to look at the listener for an extended period of time. It kind of weirds people out, because normally you look at the person that's talking. But online, that's completely fine. Like, I can see a lot of your faces now. I can watch you listening to what I'm saying. So there are some ways that technology, and obviously David is one of my mediation heroes. So for him to embrace the video-based communication, I find that a personal victory of sorts. So Jennifer, please, I saw your hand next. What did you want to say?
Sorry about that. Thank you. My name is Jennifer Kolodinsky. I'm a mediator in Flagstaff, Arizona. And like many, when we went remote, both I have some private practice work, and I've been a contractor with the county for many, many years. And I resisted it. I have now begun to, not just go with it, but actually enjoy it. And so I want to say thank you, because you've really got my mind spinning in a good way about how to potentially expand this. Coconino County is the second largest county in the country. Our county is enormous. We have multiple Indian, Native American reservations. And so I think the equal access to justice is not as fully tapped as we might do. And so we might tap it. So I'm looking forward to exploring that. And I want to thank you too as well. It heartens me so much to hear the two of you in high levels of leadership in our field talk about healing. I think mediation is so much more than just, it is solving a problem, hopefully, but at its highest form, it's about healing. And I'm so heartened to hear you use that word. I cannot tell you. And then lastly, I'm a little curious if you know the following. We have found anecdotally that our agreement rates have gone up since we went online from the pandemic, and thus we have stayed remote with my court work, we have stayed remote. I'm curious if you two know, are there active studies? I imagine there are, if there's any published data on agreement rates, since basically the whole world went remote through the pandemic. Thank you.
Thank you, Jennifer. It's fortuitous that the next person with a hand up is Susan, because she would probably know more about that than me. I will say, when talking about the ODR implementations I don't say that people get higher resolution rates in online, but they can get equivalent resolution rates. And I think there have been some studies to establish that. But there are a lot of studies, empirical studies. One of the things that I don't have data around is the durability of online agreements versus face-to-face agreements, because that's going to need longitudinal analysis. So I think there are some researchers who are looking at the data for those programs. But I think a lot of the statistics that I've seen are encouraging in terms of not that it's better, but that it's equivalent. But Richard, I wanted you to speak both to that and to the healing point, because I think
right,
yeah.
especially Jennifer on the healing point. The processes, especially the non-adversarial process we're talking about, are rich with opportunity, I think, to make it safe for people to offer apology and accept forgiveness. Because when there's a disruption in the relationship, if you can have apology and forgiveness, then people can come together. I mean, I hear these stories about in restorative justice where the mother of a child that was murdered goes to the jail and interacts with the person who committed the murder, and there's healing. That is enormously inspiring to me, that capacity actually exists. That's just amazing. The other thing I would say along the longitudinal study line, Colin, is that there's a need not yet addressed for setting up mechanisms for doing research and collecting data and doing research on the effectiveness of these various peacemaking procedures that we're talking about. And when a mental health professional here in Texas I'm talking with tells me that in the mental health field, they do research and studies on what therapeutic models are more effective versus others for any given situation. But none of that exists in conflict resolution in the legal field. And that I think is a missing piece. We need to understand with better sociological studies what's effective, what's not effective in a particular circumstance.
Absolutely.
Thank you for sharing that story too. I just want to say, I know that all of us probably have been present for what I call holy moments of apology, remorse, the full cycle of apology, forgiveness, and reconnection, even if it's in a different level. And it's a beautiful thing to be a part of. Anyway, I really appreciate what you guys have done today.
Thank you, Jennifer. Susan, please.
Yeah, well, I know, I think we're over time, so I will be brief so I'm with Resolution Systems Institute, and we do a lot of work at looking at courts and effectiveness, and I don't know, so there are a lot of things I don't know about these questions that have just been raised about what was happening with resolution rates, for instance. But the comment that I wanted to make was to bring back in the needs of self-represented parents and what online dispute resolution can do for them. We know that they're a hugely growing portion of the people who are using the courts to end their marriages, and they have a different kind of need when they use ODR. That ODR has a lot of promise in being a place where they can be educated about what their options are, etc. But that we really need to be thinking about ODR in terms of the people who are self-represented.
Absolutely.
So, Susan, what state are you in?
I'm in Illinois.
I would like to connect with you. So if you would send me an email at richard@shannonfamilylaw.com.
Okie doke.
And what I would say is that this is an access to justice for and especially present for unrepresented clients. Now in Texas, it's amazing in family law cases, it's approaching 50%, and if you have only one party included, 60% of cases have at least one party unrepresented.
Yep,
that's pretty amazing.
It is.
And in my view, that's a total breakdown in the adversarial judicial system. The adversarial judicial system assumes that parties are going to have an effective representative, a lawyer. And if they don't, there's already a big imbalance, and a judge can't address that. It's not their role to do that. So what we're looking at is taking some of the processes that exist, such as combining mediation and arbitration, but not traditional arbitration that's reformed to be more, I would say, less adversarial form of arbitration, which is more inquiry and information gathering, combined with mediation by a single professional that is helping people reach agreements.
Well, we could spend the rest of the day talking about that.
That's why I want you to contact me so that we could continue that.
Well, Carmen, I see your hand. If you have a quick point, I'll let you in, but I want to get to Darren and Anita. But what did you want to say?
I just wanted to say that, mediation, the availability of it is tremendous, in a tremendous need, because I've worked with a couple of people that their lawyer it's no offense to any of the attorneys here, they're $400 an hour. How many people can afford $400 an hour, or an $8,000 bill every month with, they've been going on for 6, 7, 8 months to a year, and they're nowhere near being having any kind of resolution.
Mm-hmm. I think we've all seen that. Yeah, it rends your heart. Yeah.
And how do you level that playing field if one person can afford that $400 or is figuring out how to afford that $400 an hour, and the other person just can't?
Yeah, absolutely. Absolutely. I think the other thing is people feel like they have to pay that amount of money to get a divorce because they don't know about the alternatives. So that gets back to what Richard was saying.
Well, and in high conflict custody cases or divorces, you're spending tens of thousands of dollars.
Right.
Because anything can be brought to the courts because that's our right. Even if they're false accusations, and then they're just drawn out. So,
well, I'd like to take that topic and give it to our next panel to chew on, because I think we are a little bit over time. But Richard, I want to thank you so much for doing this first panel with me, and thank you for all the great work you're doing in Texas. And I'm glad you're on that task force, because I know it's going to go in a healing direction because you're there.
Well, thank you so much. It's been my pleasure to share.
Excellent. Okay, without further ado, let me hand it over to my friends Darren and Anita for the next panel. So please, Anita and Darren, take it away.
All right. Well, first of all, thanks for having us here. And Darren, why don't you tell them a little bit about what you do and what you've created in Canada?
My name's Darren Gingras, and we are a company that's called SIЄSDE Dispute Resolution Technologies of Toronto. We are fundamentally based out of IBM's innovation program here in Toronto, and specifically, we develop dispute resolution technologies. So you will notice that I use different language than ODR. We create dispute resolution technologies specific to family and family law services, again, based here out of Toronto.
Great. And so how long have you been involved in alternative dispute resolution and online dispute resolution in Canada generally?
We actually come from an existing family law collaborative mediation process. So we've been existing for probably a decade and a half. My background in ADR goes well before that, but specifically focused on family dispute resolution for the last 15 years.
Okay. And in Canada, do you have, see here in Texas, we have to be an attorney to be able to basically have a mediation practice, because they've made it real hard to be a non-attorney mediator. Is the same, do you guys have the same problem in Canada, or?
The same, we don't have the same problems. No. To reframe that one, in Canada, family dispute resolution processes, I would probably say that right across the country and in all of our jurisdictions, they have been quite progressive when it comes to understanding family dispute resolution. Certainly mediation is not at all the realm of attorneys and lawyers only. In fact, I would say predominantly most family mediators are not lawyers, which of course creates other processes. We have independent legal advice. It's a part of our processes up here. But it also means that we have a full spectrum. And that's where you're hearing me say I'm part of a collaborative mediation process that includes mediators, that includes family lawyers, that includes financial professionals, that includes divorce coaches, that includes collaboratively trained what we call ancillary professionals, real estate mortgages, et cetera, that are all a part of this process with the entire goal of family dispute resolution. And I don't think, there was a time that we were probably pretty ahead of the game on that one. I don't think we are necessarily anymore. I think we're quite typical as far as being open to all kinds of professionals in FDR now.
That's great. In your eyes, what have you seen as being the problems that people have experienced with ODR, and what did you do to try to go about solving those problems?
I mean, online dispute resolution, you have to understand, I'm always approaching this from a business perspective, and we're approaching this from a technology perspective. Online dispute resolution, Colin has always piqued the interest of individuals like myself. They're talking about the future, they're talking about trends, they're talking about where we're going. And I think there was a lot of us that could see that. Of course, we're going that direction. It's just, for a lot of years, I think we were all having conversations that hadn't quite yet happened. And we were talking very much in the future. And good, bad, or ugly, COVID changed everything, changed the market, changed our perceptions, changed the way we all ourselves use technology, changed the way we as professionals. I think that whole COVID experience, probably moved the legal industry forward with regards to technology than just about anything else ever could have. But it changed right across the line. So perceptions have really drastically moved. The finish line has moved in the last 4 years. So people are open. There was a time when there were technology companies like us that were way ahead of the legal industry, and the legal industry was drastically behind and the market was somewhere in between. Now I would actually venture that, of course, the technologies, the industry is way ahead of everybody. We've seen that drastic jump, but the market is also way ahead. The market has changed. The market is not interested in what we are typically or traditionally have been offering. The legal industry, though, I think we as family dispute resolution professionals have moved towards where the market is. I don't know that we're fully embracing where the market is right now. And that's translated into business as seeing the opportunity. I don't know that we're always seeing the opportunity. And I'm not even talking about access to justice or reforming family law. I'm just talking about the opportunity for our own individual firms to dominate or capture market share. The market shifted, and this is not the same world that it was in 2020. Sure.
Would you mind sharing with the audience what you created in your PowerPoint presentation? Because I think it's fascinating. I think they will too.
Well, let's do this one. Okay, so if I could just share my screen. All right, so really quickly, if you'll allow me just to sort of fly through this one. Again, our company comes out of an existing family law mediation process, so it's really important that people understand, and let me share from the beginning here. It's really important that people understand that we have no agenda. We're not here to fix the world. I am not here to fix your court systems in Texas. I have no desire to fix every legal system that's broken. That's not our agenda. Our agenda was specifically to develop the online dispute resolution processes for our existing firm. And we came from an existing firm. As I said, we were a family collaborative mediation process. When we established, we were actually very fortunate. We were at the beginning of a curve that was shifting with regards to family mediation. I remember back then, to be very honest, when we were buying Google words, we were buying meditation because nobody knew to Google mediation, and we were actually getting found more with meditation than we were with anything else. Collaborative, I still don't think that word exists in the vocabulary of the entire market. Nobody is Googling collaborative law. As far as trying to find these kind of processes. So we set ourselves up really with the agenda of addressing what would have been at that time the traditional family dispute resolution processes, quicker, cheaper, more amicable. We were very fortunate to tap into a very well-known Canadian celebrity financial influencer, and very quickly we took market share. Very quickly we became established. We definitely became one of the largest processes going back a decade or more ago, right from the beginning, just simply on that agenda. Very quickly, though, we did come to realize the limitations of that sort of traditional FDR process. You know, I certainly don't have to explain to anybody in this room, everything about family law is complicated. Everything about it. Complicated people, complicated processes, complicated laws, complicated financials. And even though I would arguably say that we had some of the best family mediation or family dispute resolution professionals in the province were working with us, there was kind of a trade-off that was going. There were limitations in what we were able to offer as an FDR process. Trade-off, you know, in order to be quicker, cheaper, amicable, we were sort of the trade-off when it came to complexity, asset values, limitations of what that acrimony could be. And not only that one, we also started to realize very, very quickly that we were, just as a collaborative process, so ripe for human error. There was incredible amounts of professional misunderstanding. So probably more than anything else, I think that we really struggle and we're frustrated with is we could not standardize a process. So in other words, we were not trying to fix the entire industry. We're not trying to fix every scenario, but we wanted to be able to grab a certain demographic of the market that we were wanting to work with, and we wanted to be able to standardize a process. And we really struggled with that. We struggled with centralizing processes. You know, something as simple as signing a document literally had to happen in a location. We were limited by 7 office locations across Southern Ontario. In Ontario, of course, where we were having to have independent legal advice for every client that was going through a mediated process, that meant we had to have 2 ILA lawyers in every town, have a third one in case there was some sort of conflict going on. And to be very honest, very quickly, we started to hear the feedback from the market. Clients were complaining. We saw the Google reviews that we didn't want to see. And we also started to understand that that process that we were trying to build as a business model, which all of us would love to see as a major business model taking over wherever we are, it really came with a lot of challenges as a business model. Arguably, some of the most expensive professionals work in a family mediation process. Lawyers are $400 an hour. Mediators are $350 an hour. CDFAs are $375 an hour. This was an incredibly expensive process to try and standardize. And to be very honest, if I was to go back to when we started, you know, looking at this one a decade and a half ago, I just personally found the entire industry hostile when it came to any kinds of innovation. Change was just a dirty word. New certainly didn't ring excitement with just about anybody. And if anything, I have learned, and I say this with a smile on my face, I sit on every ADR board you can think of, but nobody can scrap like ADR professionals. So, you know, it really was a world where we were struggling to figure out what was next. And by 2017, we had had enough. We really needed to figure out if there was a way that technology could help us. And where we started with that one is we really had to go back to the whiteboard and we had to revisit our assumptions, and we had to revisit what we had understood about divorce. So what we were realizing is that many individuals really saw divorce as a legal document. It really was at best a legal process that had a start and a finish. Maybe there was a court involvement or some sort of professionals that were involved in the midst of the process. And this really was the way that we, and not only we, you know, the majority of the world around us was understanding divorce. In reality, though, we really started to realize that divorce doesn't look like this. Divorce looks more like this. And divorce was a process that had a very clear before, during, and after. And, you know, our research started to show us that people were researching their divorce 5 to 7 years before they were getting in touch with any of you as professionals for a process. And during that process and after, you know, there's great research that's coming out of the University of Tennessee that's talking about the cost and the implications of divorce dragging on for up to 7 years post-signed separation agreement. So we really started to realize that this divorce process didn't look like the way we were assuming it was look like. In fact, it was complicated and it was convoluted. It really wasn't just about the legalities that was causing the drama. We started to realize it was obvious, the things like domestic violence, but it was relocation and children in new schools, and where there was one mortgage, there's now two mortgages, and financial challenges and retirement planning and re-educating and re-entering that workforce and dating again. One of the things that really surprised us is when we had that eureka moment, we realized that the highest paid professional in this entire divorce ecosystem was not the family law attorney. It was the real estate agent. And, certainly we're finding this here in Toronto. Nothing is causing more drama right now in family law processes than real estate mortgages. We recently had a client come through our office where they were being nailed in the midst of their divorce with $75,000 penalties for breaking their mortgages. So we really started to understand that this really wasn't about a process. It really was about a divorce ecosystem. It really was about a major life juncture, and that dispute resolution wasn't really about just finalizing a legal document. It was about walking people through this entire divorce ecosystem. So what we did at that time is we really started to step back, take a look at this, and we were very much interested in where the market was going. And one of my first concerns is I was a little bit concerned, or we were concerned, that we were not moving where the market was moving. Now, this data, if I'm assuming down in the United States or in Texas, it's very similar. It's hard to get data when it comes to what's really going on when people split up. You can track a divorce, but that doesn't take into consideration those people that don't formally divorce, and it certainly was not taking into consideration the individuals that were common law. So we were trying to gauge, and we started gathering data. So this is a reflection of about 3,000-4,000 individuals going through. We started to wonder whether or not we were actually moving where the market was moving. And this was going back to about 2017, we started gathering this documents. People were aggressively reacting. The market was reacting against traditional processes. Now, I'm not trying to say that this is the way that it is in Ontario. I'm saying this is the clients that were popping up in front of us. These were individuals that were researching their divorce. These were individuals that were looking to move forward. What was going through their process? We did realize that we needed to rethink our business models. So as I say that one, it's probably really important, before I show you what it is that we do, is to tell you what we don't do. We do not do quickie DIY online divorces. And as I say that one, I also sometimes do need to reiterate, I know that it's very different in every state and certainly here in Canada and in every province, what we mean by this language, but I do find it very important to point out, certainly where we are working, divorce is not the end line. Divorce is an application, you fill it out, you send it into the courthouse, a judge signs it, rubber stamps, and that ends the marriage. Getting a divorce online is really not a great accomplishment. The challenge was the separation process. For us, we create a separation agreement. That parenting plan is part of that separation agreement, the division of assets. That's what we were talking about. That's where we wanted to be working. So we're not about online quickie divorces. That's not what we do. We do complicated files. We do kids, we do mortgages, we do support. What do you call it in the States? We do alimony, we do pensions, we do debts, we do taxes. And we really, from day one, wanted to be about doing it the right way. So that meant for us full financial disclosure. We really wanted to make sure we required that everybody was receiving full independent legal advice. We were interested in helping clients generate legal documents that were enforceable and binding, and that really meant our processes had to be about dotting the I's and crossing the T's. But we were also not interested, and we're still not interested, in using technology or AI to generate a finalized separation agreement. That really wasn't our agenda. And the reason, of course, with that one is that technology is, that divorce is complicated. We were interested in whether or not technology could help us to deal with the drama, whether or not technology could help us to minimize the dispute, not just generate a robot written separation agreement or parenting plan at the end. I've kind of always struggled with the traditional models of ODR that seem to be jumping towards the finish line, because the reality of this, you know what, folks, you get this one. If divorce was just a legal problem, maybe we could do that, but it's not just a legal problem. It's an emotional problem. It's an emotional challenge. You know, any professional that's worth their weight in salt could pretty much tell you where this is going to land. When that client walks into your office that first morning. The reality is they're not done spanking each other, and that's where this divorce process has to go through that entire ecosystem. So we really wanted to see a goal set that technology was there to help us to break down complexity of the process, complexity of the experience for our clients, for our collaborative professionals, complexity of a business model. And if possible, we just wanted to get ahead of that dispute before it even happened. So for us, that we sat down, and this was in 2017, and we set out our new agendas, our business goals. Number one, standardizing a family dispute resolution process. So again, obviously, let's say it. We cannot pretend to offer our services for everybody. That's not what our goal was. Our goal was to say, here's our demographic. Can we actually focus on a standardized family dispute resolution process that emphasizes that journey over just the destination of a completed separation agreement or a completed degree? We wanted to address the real issues, not just the legal issues. And of course, I don't mean that the legal issues are not real issues, but we were concerned about, you know, those agendas, mortgages. You know, frankly, folks, you know, people were going through this process where there was one mortgage, there's now two mortgages. Throw in a girlfriend, there's three mortgages. These were real agendas. They are real agendas that people are facing. Retirement planning and moving forward and retraining and getting into the workforce again. These were the issues that was really causing the dispute that we were wanting to address. Tech efficiencies, you know, really, could we steal technologies? And you heard the word there right, steal. Could we steal technologies that would minimize, bypass, or resolve disputes? We literally spent our first year, went out and stole technology, and I say that the nice way, from the financial industry, from the mental health industry, from healthcare. Was there technology that was being utilized elsewhere that we could bring back to this divorce ecosystem that would help us to create efficiencies that would minimize or bypass that dispute if at all possible? And lastly, it had to be a sustainable business model. This is me talking. I personally had no interest in creating something that didn't have a lifespan beyond a bad plan. I actually get very frustrated with so much of these legal innovations that happen with no business plan. They're a great big explosion of sparks and fireworks, and poof, they're gone in a matter of months or years because of a lack of a business model. So we really did want to create a sustainable business model that would allow us to continue to be innovative. And what that meant is we set out in 2017 and we created a platform called ODIN. So ODIN, I guess it's short for the Ontario Divorce Information Network. It is now, Odin is the Norse god of knowledge, the Norse god of war, which pretty much, I guess, covers divorce. And right from the beginning, this back in 2017, we decided to focus on the boring stuff. So you got to remember, we're not looking to create an online separation agreement. We certainly have dabbled with those things. That's a whole other conversation. But that wasn't our goal. Our goal was very much the boring stuff. And back in 2017, you know, people were asking me, why are you not focusing on resolving the issue? Because we knew family law, we knew the family law process, we knew that ecosystem. If we didn't focus on those core things, you know, the boring stuff, collaborative file sharing, document generation, storage of documents, CRM, financial disclosure. Oh my goodness. If I could literally sit there and have my one moment of saying, you know what, we were right on this one, it was financial disclosure. I remember that 2017, we'd be talking about how we were trying to emphasize financial disclosure. And I would see individuals look at us like a mule looking at a new gate, and not just getting why we were doing this one. Well, we realized that we had to start looking at these core processes. You know, we were managing tens of millions of dollars in assets every month. And we also knew that based on our research, we had partnered with a number of law firms across Ontario, that it was taking on average 100 days for a client to complete their financial disclosure process. We started to realize that there was a correlation between those 100 days and the increase of domestic violence. If there was going to be domestic violence, it was definitely increased during that time before they were able to get in front of their, selected process, their mediator, their lawyers, whatever it might be, waiting for that financial disclosure. We wanted to create efficiencies, if anything, to make our job easier, to make it easier for the client, but to see if we could minimize that time for the sole purposes of getting ahead of certain domestic violence situations as they were created. This was getting ahead of the drama. Now, beginning of that process back in 2017, we were busy. We had a market share. We were averaging at that time about $4,000 per client, $8,000 per file. When you're talking family mediation, that's sort of good middle of the road. But to be very honest, there was a lot of talk of ODR. There was a lot of technology. This was certainly not very exciting. People really, we were not seeing anything happen. We're certainly not here in Canada, certainly not when it came to family law in general. And to be very honest, it was just downright discouraging. If you were to talk to me in February, 2020, we had spent a lot of money to develop this. And I kind of wondered maybe we'd missed the boat. Maybe we had heard the market wrong. And I was kind of wondering, where do we go from here? And then in March 2020, COVID happened. And I'm telling you folks, all of a sudden we became the cool kids on the block. COVID changed everything for us. Certainly, not only was there a shift in professionals, and I probably would venture that this was more of a have to rather than a want to, but there was a shift. But we instantly saw a shift in the market. And the market, they were now all of a sudden ordering their groceries online. They were working from home. Their attitudes to online services dramatically shifted. In March 2020, we simply just plugged Zoom meetings into our Odin platform and we were ready. And our market instantly responded. We instantly saw an uptake in the massive uptake of online services, our processes and our technology, but it also bought us time. Time to flesh out more of those functional ODR processes that we had been wanting to work on for a long time. So now we finally had the time and the resources to work on a triage process or an online independent legal advice. This was a game changer for us, or marketing, or taking the time to develop a virtual negotiation room. So at that time, which was also interesting, is where everybody else was struggling, our client revenue doubled. Not only did our revenue double, our client volume doubled, and our expenses, as far as walking people through that process, actually cut in half. As we move towards the end of the pandemic, we had to make a business decision. We knew that the market had shifted. The market had shifted. They were responding to where it is that we had followed them. But we also knew that the majority of our industry, certainly here in Ontario, was itching to get back to doing it the way that they had done it before. We made the decision to jump. We actually shut down all of our in-office locations, and we started investing in our ODR technologies that would better facilitate what we were seeing as true realities of those divorce ecosystems. So it wasn't just about the legal processes, though we definitely had been working on developing those. We were now moving into ancillary services. How can we better facilitate some of those other dramas that were going on through that process? So we worked on increasing the volume. We have spent time working on the complexity of our files, higher matrimonial assets. We definitely have increased drastically when it comes to the acrimony levels of the client files that we're now able to work with. And more than anything else, we started targeting the clients, that segment of the market that we specifically wanted to work with. More than anything else, we really just wanted to get our first 1,000 clients through an online dispute resolution process. And at the end of our first year out of COVID, our client base again doubled. Our revenues per client increased to just shy of $20,000 per file without raising the prices of divorce for our clients. That's a really big one, folks. We didn't raise the price of divorce. We actually were able to maintain that price of divorce, but see the revenues increased. That's a business model. Now in 2023, I can pretty confidently say we will never go back to the way that it was before. our market. We do make available premium services if clients would want to meet us in person. We just simply do not have clients asking us to meet in person. It just never comes up anymore. And in 2023, our business model has been incredibly good to us. We have been incredibly religiously orthodox in holding to our established business model. Tech is incredibly expensive. So we literally in the last year just sort of took the year, we pulled over to the shadows and just worked at grabbing our market share, dominating in what it is that we do. Took a year to just grow our revenues, pay off all of our debts. You know, you're building technology, this is millions of dollars. So we literally put that investment back into us. I'm not going to say that we are the biggest or the world changers, but I am telling you right now that online dispute resolution, as far as our firm, has been a game changer. Our data is showing that our ODM systems, to date, we are now facilitating annually about $1 billion in matrimonial assets. Now, let me stop there and just stop on that for a moment. $1 billion of matrimonial assets. Start thinking of the drama, start thinking of the human error, start thinking of the complications and the complexities of those scenarios. The fact that Odin is able to facilitate us with that one is a little bit mind-boggling of how we've got ahead of the drama that's involved with $1 billion worth of matrimonial assets. Triaging, this is a regular part of our process. We triage now about 10,000 clients, individuals in Ontario. That doesn't mean they all come to us, but we do triage about 10,000 individuals and facilitate sending them towards legal aid, facilitate towards sending them towards traditional litigation lawyers, or move them towards a collaborative process like ourselves. To date, as we stand right now, Odin has directly assisted. We are now just shy of 3,500 clients through their entire divorce settlement process. So we're talking kids, parenting plans, pensions, separation agreements, ILA, and applications to court. We again, have over and over revisited those assumptions that we had on that divorce juncture, that entire divorce ecosystems. Our revenues have shot up again. We're now at about $14,000 per client, just shy of $30,000 per file. Again, without impacting the cost of divorce for our average clients. This is a business model. This is how we are facilitating people through. We see it as our own personal slice of access to justice. How is it working? That's always a challenging one to measure. I do not claim to be an academic. I am not somebody that's going to stand in front of you and spew anything else. I'm a businessman first and foremost, and I go back to what it is that our market, our clients are saying to us. And I think, what amazes me more than anything else is the feedback we get from clients. Sometimes I actually smile. We get clients, and I'm not pulling this one out to wax ourselves. I get clients come up to us to not only thank us for the process that they went through, but to tell us how much they actually love the team, the staff, the process. And I often walk away from these scenarios going, who talks that way about their divorce process? Who loves anything about a divorce process? All of that said and done, this is where we're at now. This is our online dispute resolution process. This is where it is that we're developing. What we are, where we're going, is a reflection of our own firm, our own beliefs, our own models. But this is how online dispute resolution is playing out for us here in Ontario, and how we are being a part of that ODR discussion here in Canada.
That's great. Thank you. I want to ask a couple of follow-up questions in terms of, you said you're getting ahead of the drama with matrimonial assets. And you also were discussing the fact that when you started, it took about 100 days for clients to gather all of the financial information. And in that process, you were seeing there was a correlation between the drama, domestic violence, all of that increasing at the same time. Can you share with the audience what tools you put in place to assist that? Because I think that is one of the big problems with, clients who are going through a divorce, is that they don't understand why they're being required to give financial information, for example. So how did you help them and modify your system so that it was an easier process for them?
So there's actually two different answers to that question, two different questions going on. One is obviously a technical. How did we make that process more efficient. And I can certainly give you a quick over that one, but there's actually more of a psychological question. And for scenarios, helping clients to understand, we pulled out a legal tech. We moved back to behavioral economics, and we moved into the financial industry to ask questions like that one. So maybe a better way of assuming this one is, when we think of technology, we've always understand how technology is able to do a utilitarian. This is my line: utilitarian moving of data. We know that you can take $10 from your bank account here, you can push a button and transfer it to $10 of the bank account over there. Behavioral economics and behavioral science has always understood that technology can be involved in behavioral augmentation. So in other words, can we use technology not just to move data, but can we use technology to change the way, for instance, people save? Or can we use technology to change the way that people plan for the retirement, or to get themselves out of debt, or to get their, to repair their credit bureaus? That's behavioral economics. And so we really were interested in the behavioral economics and the psychology behind helping people to understand why we need to do something like financial disclosure. So we actually took a totally different approach. We didn't give a legal answer. We talked to people saying, this is what we need to understand about the process, where you need to be. Explaining to a mom, for instance, about how you are not going to be living on a bench at the bus station, and part of that understanding is, let's get on top of our finances at this place. Let's get a measure of control, and maybe approaching it from that direction, help people to say, you know what, I want to get involved in my finances. So again, of course, we require it, but we started working earlier with them to say, can we change the way you're thinking about your finances? Why this is so important. By the way, it's also going to be required as you go through your family law process. Technology, we kind of did the same thing. I'm probably sure that all of you did originally. Clients would email in their financial documents, or they'd get a Dropbox and they'd put them in there. And every Friday, somebody in our office would go through those documents. They'd have sent in, 70 documents. We'd pick out the 12 that were right. We'd send back all the rest back to them. They'd say, of course, we'll get those back to you in 3 days. 3.5 weeks later, they'd send us another 70 documents, and we'd start all over again. And it was just a tedious process. It was tedious for us. It was tedious for the client. And more important, that tedious element of the process was working against us when it came to family dispute resolution. So in other words, the whole experience, the user experience, we haven't even started the family law process. Already the process was tedious and horrible. And that's why we started there.
Got it. And in terms of the average time that it takes your clients that are in your system using Odin to get that financial information to you, how long is it taking now with the systems that you've implemented?
So now we're seeing our clients do full financial disclosure, and full financial disclosure for us here in Ontario, it's usually about 50 to 70 documents. We're seeing full financial disclosure completed in 7 to 10 days. We have now, and we could have been faster, but we weren't. The market wasn't ready. The market is now ready. We're actually in the process of incorporating in what's called data aggregation. By this time, by Easter, we'll be at a place where full financial disclosure will be completed within 48 hours.
Amazing. That's absolutely amazing. In terms of client satisfaction, what is it that they are sharing with you in terms of what's working within your system that you're offering versus what else is out there?
Clients don't know what else is out there. That's part of the problem. That's part of the problem when you build a business model. What are you going to compare it to?
Sure.
And so we couldn't use that as a measuring stick. What we had to do was actually listen to our clients. It doesn't matter if we were to get our financial disclosures done in 48 hours. If they still find it onerous in 48 hours, it doesn't matter that everybody else takes 100 days. So we really did have to start taking a look at that client experience. And where we were hearing, I'm going to use the word discontent, was when clients were waiting, when somebody was not getting back to them, when they couldn't reach somebody, anxiety in the middle of the night, angst, when there was I call them the little itty bitty shitty voices that were going on in their heads that were playing out in the middle of the night that was causing them to make bad decisions. So we really started looking at implementing tools that would meet them at that time. We partnered, we call them ancillary. We partnered with a local company, for instance, that will take care of wills and estates. And there was a bit of a delay we had between the time of drafting of that formal separation agreement till they could meet with their ILA lawyer. Let's say that there was 10 days. You know, this is probably a really good time that clients could take care of their will and estate planning, keep people busy, keep people occupied, allow them to see where they are in a process. That was a big one. Where clients are in the process. If you've ever, drove to some new place the first time, it takes forever to get there, even though it's only an hour and a half away, because you don't know where you're going, because you don't know where this, it takes forever to get there. It seems 3 times longer because you've never been there before. That's our clients. They don't know where they're going. Could we use technology to help them to get a sense of where they are in this process? Even something as simple that said, you know what, you're 70% completed your financial disclosure, and here's what we got left. Just markers that allowed them to see. We found actually brought around a sense of ease and definitely reduced anxiety, which definitely had implications on getting ahead of the dispute.
That's great. You started off your presentation by saying we are not a company that's doing a quickie do-it-yourself divorce for families with little assets or no kids. Is it as a regular part of your business? Do you guys have families who are in, or parents who are in deep conflict? And what is the mechanisms that you use to try to assist them?
I mean, obviously, and let me never minimize the level of professionals that work for us. I have no problem. This is not a business label. This is boasting. I have some of the best professionals in the province are working for us. So we really do have a gifted team of people that work with us, mediators, family law lawyers, CDFAs, whatever it might be, that definitely are able to take a lot of the heavy lifting when we're working with these processes. It's just that the technology is allowing us to target very specific demographics that perhaps would not have been available to us as a traditional mediation model. We specifically target narcissistic personality disorder. We actually have an whole entire agenda of targeting narcissistic personality disorder, and no mediator targets narcissistic personality disorder. We do, and we have processes. I'm not giving away the secret in the sauce, but we do have processes, and we utilize that technology to help people go through this process, help to bring clarity. Domestic violence, it's certainly not the majority of our files, but it's a regular occurrence in our files. High asset files are a regular occurrence in our process, regular. And again, that technology helps us to go into markets that I'm not so sure before we were able to facilitate.
Wow.
Anita, this is such a great conversation. And Darren, I just find this fascinating. Carmen just posted something that said she'd love to see more about what you're doing with narcissistic personality disorder. So that's interesting. But I'm cognizant of the fact that we have one more session. Do you want to wrap it up? Do you have final comments that you'd like to make, either or both of you?
Yeah, Darren, why don't you go ahead and wrap up anything else that our audience needs to know?
This is an industry. I certainly don't in any way claim to be the experts. I'm in the room of experts. My observation as somebody that has come to this one honestly and legitimately, we were not creating online dispute resolution as a business model to make lots of money. That wasn't first and foremost. It really wasn't. This was a genuine desire to facilitate family dispute resolution here in Ontario. What I will say is the conversations perhaps are happening in the wrong places. If I could be very forward, there's a lot of times I purposely don't speak much anymore. I don't speak to conferences. I'm really not interested in talking because I'm not interested in finding a bunch of people that are my age or older and arguing with them about whether or not the world's going to change. There are young lawyers that are coming out. I have young lawyers that work with me. I have young mediators. I have young, ADR professionals. They're already there. They don't need to be convinced. They're going. So, really what it is right now is I'd say, folks, this is not a conversation about whether or not it could, should, would, or shall. It is. Where is our role moving forward with that one? And I can guarantee that if you're looking at it as a productive mode, there's plenty of productive places to be involved.
Great. Thank you. Thanks. Colin, I'm not sure if anyone had any questions, but if not,
well, maybe we can do some questions at the end of Laura's presentation too. We'll see if we have some time. But thank you so much, Darren. Thank you, Anita. That was fascinating. And let me hand it over to our third panel, Laura and Tawana. Please take it from here.
All right. Good afternoon, everyone, at least Central Time. So today we have Laura. And Laura, if you would, I don't want to say your last name wrong. So if you would provide the correct pronunciation of your last name, that'd be wonderful.
Hello, my name is Laura Kistenmaker. I'm from the Netherlands. So I'm not a native English speaker, so I hope you'll bear with me with my English, and you'll step in when I start to say the wrong things.
Yes, no, and welcome, Laura. We appreciate that. So one of the things that Laura is going to be talking to us today about relates to an article that she authored. And I believe, Laura, you authored this paper in 2021, is that?
Yeah, that's
okay.
Correct. Yeah.
And if you would, Laura, give us just a little bit of background for the basis of your paper. And I understand that in the Netherlands, starting back as early as 2007, that the Legal Aid Board started a website that was to help assist people looking to get divorced for resources. And then later on in 2014, it added an ODR component for people to actually interact and be able to facilitate divorce procedures, more or less like a self-help, that they could do that on their own. So could you give us a little bit of an idea of how that came about and its uses in the Netherlands?
Yes, absolutely. And maybe after looking back, I could also explain a bit on where we are now with actually the follow-up platform of that period, and then I could also share some slides to give you a sense of that. But indeed, as you were already sharing, we in the Netherlands, the Legal Aid Board, the Dutch Legal Aid Board, was really a pioneer when it came to developing self-help tools for people to use in different areas of conflict. And the divorce, the family law area was an important focus back then as well. And indeed, back in 2014, the Legal Aid Board, together with the Hague Institute on the internationalization on the innovation of law, and Modria, developed a what was called then in the very unpronounceable Dutch way, Rechtwijzer uit elkaar, as a way to facilitate indeed self-help for divorcing couples in amicable divorces. And we piloted, or we've run that platform for 2 years in the Netherlands, and we got a lot of good experiences with users. It was very well received, and very importantly, we also had very good feedback from the lawyers and the mediators that we were working with.
And so, we saw in looking at the article, I saw that from the percentages when people were surveyed, it seemed to have a high percentage of people that felt that going through that process, that they had a lot less pain, like emotional pain had been decreased participating in the ODR program, as well as they found that their communication with the other person allowed them to make agreements that actually worked rather than maybe something they felt was forced. If you could, or if you have available, what kinds of issues were coming out of the divorces within the Netherlands that led to a success with the ODR?
And you mean like specifically within divorces in the Netherlands? Or
Yes,
maybe
yes, were there certain issues that the lawyers were seeing within divorces that they felt could be resolved better, maybe through using an ODR method?
Well, one of the things was that as this is 10 years ago, of course, but what lawyers were sharing was that when clients came to their offices, they were often already had gone through this extensive Google exercise of finding out all kinds of information themselves from different sources, one more reliable than the other. And then often they found some template online for a parenting plan or maybe even divorce agreement. And they already kind of started some of the work themselves. And while the lawyers and mediators saw that this served the purpose, they also had to spend quite some time and effort to kind of guide the couple back when they went off on the wrong direction, or whether when they sourced their information from when their information came from sources that were not so reliable. So they were seeing that there was this, of course, this urge for clients to find information and to prepare themselves, but without really any kind of qualitative guidance in this.
To be able to do that. And so now, in terms of the technology that's available today, including AI, how do you see that benefiting online dispute resolution as well as assistance in self-help for couples that are divorcing?
Yeah. Well, I'm sure you have been talking about this already with the previous speaker, which I wasn't able to hear. But I think AI will, of course, have a huge influence on our work, especially in the family law area. But I do think that it all starts with having data first, right data, or the experiences, because and that's the take that we have at this moment with our platform, that we're awaiting what the next developments will be in AI before really embarking or investing or starting to invest in this. But I do think, like, and I will show you later on how our platform works. But what we already do now is give our clients back what would be what other people in similar cases agreed to, or how they structured their agreements. And this is based on a simple algorithm and on intervention of the case managers that we have. And I think this part of our platform is very well suited to also insert AI in, because then you can take a lot more data points of people's situation and match them far better with previous successful divorces, and then offer people suggestions, which I think it should be suggestions rather than just a fixed solution for people, but something that they can start off with, because our experience is that a lot of our clients ask the question, what did other people do in a similar situation? I think AI can be of great value there.
Okay. And so, Laura, I know that you have some slides and some other materials that you want to be able to share. So with us, if you want to be able to share your screen now and do that and kind of explain to us where that process is now and how you handle that in the Netherlands.
Yes, I gladly do that. Let me share the screen. I believe you are seeing my screen.
Okay.
now?
Yes.
Yes. Okay. So, like a previous speaker, we have a version of do-it-yourself divorce, but we rather call it a hybrid, kind of self-guided and supported ODR for divorce. And yes, I would like to touch on some background and then give you a run through through the platform for you to have a kind of sense of our product.
Certainly.
So we set out with a mission to build a user-centered divorce process supported by technology, because we saw that a lot of the processes in family law were principally designed from the perspective of the professional or from the governmental organization. And the idea was, what if we turn it around and take this divorcing couple as the starting point? How would they like to go through that process? And as we already discussed, it started out as Rechtwijzer, which had a preparation phase, but we were live from 2014 till 2016. And then the legal aid board in the Netherlands said, well, this should be a service that the legal market should take over. Their position, that was, we as a Dutch government, we've supported the initial stages of this innovation, and now the next step should be done by the market itself. Yeah. So I was part of the team that back then developed Rechtwijzer, and together with some colleagues, we decided to turn it into a separate entity, which is Justice for Two, and we kind of spun it off from the initial organization that was set up to run the predecessor. Okay. So we're an enterprise. We're not dependent on governmental subsidies anymore. We're financially self-supporting, but yeah, generating income is the goal is to create a service that's financially sustainable rather than that will generate a lot of income. Okay. The idea is to be independent of subsidies. So
and when you're saying funding, just so we can understand, again, the funding is through the fees that are paid by participants, correct?
Yes, there's exactly, but there's actually a second, and there the government is important. In the Netherlands, the legal aid, the financial legal aid for divorce covers around 40 to 50% of the divorcing couples. So 40 to 50% of the. So we have our own regulation within the legal aid law that we as a platform also receive the financial legal aid. So from that target group, we only receive an own contribution or a self-contribution, and then we are also paid by the government for these cases.
Okay.
So that's our second revenue stream.
Okay.
So since then, since 2017, we're now, I think, we're in the top 5 of the largest divorce service providers in the Netherlands, and we're the only government-approved divorce platform, which for us is, as a private entity, is very important because we're approved governmental organization, and independent parties can refer to us as a way to organize the divorce. Because we're not a governmental organization, we really need to do our own marketing, and that's what we have focused on a lot the past years. But by now we are an established brand, and we have an online presence in our fairly small market, which the Netherlands is. We have around 30,000 divorces per year. So, and we have 35,000 unique visitors per month. So we cover quite a large part of people looking online for information on divorce.
Okay.
By now, we completed over 2,300 divorces. And as I already explained a bit, we are a do-it-yourself tool to some extent, but we do work with lawyers, mediators, and other divorce experts in the fields.
Okay.
As we're a social enterprise, we also measure our societal value through a certain method, and through that method, we're able to calculate that every euro spent on autocar yields a societal value of 5 euros. But maybe more importantly, customers are satisfied, give us a good customer ratings, and lawyers are also happy to work with us because the time spent on a case is reduced by 60% compared to regular cases.
Okay.
And recently, the Legal Aid Board researched how our clients, they compared our clients with the regular population of in the Netherlands of divorced couples, and they concluded that our clients have 80% fewer follow-up proceedings, court proceedings, than the average divorces. So our claim that we want to stimulate de-escalation, now is backed by some research, which we find hopeful and appreciate. So before going into our product, maybe to explain a bit about the divorce procedure in the Netherlands. In 65% of the cases in the Netherlands, spouses jointly petition for divorce, and that's our target group. A lawyer is mandatory, but they then can use one lawyer jointly. To petition for divorce, there needs to be a parenting plan and a divorce agreement. Parenting plan if they're minor children, of course.
Okay.
Mediation has been stimulated by the government since 2005, and the parenting plan is mandatory since 2019. And around 1/3 of the citizens in the Netherlands are eligible for legal aid. but more around half of our clients is eligible for legal aid. So we are a bit overrepresented in the subsidized legal aid target group. Because of it being a joint petition, our clients are basically willing to cooperate. They need to be willing to work online, so there needs to be a level of literacy and being comfortable with working digitally. And when there are, it's not only for the simple cases, but if there are financial or fiscal complexities, then additional help is added to the platform. The majority of our cases have minor children, and we also do cohabitation next to divorce. So our process follows 3 main steps, and the most important part is the preparation phase, because that was, I already shared with you that what in a way what our platform searches to fix is to organize the preparation of the divorce. In the Rechtwijzer time, in the period when the predecessor, this was done fully digitally with no human support, and with our new platform, we added case managers to support people in this process on a need basis. And then the second phase is the lawyer phase, and the third phase is the court phase. And actually the court phase now is up till now it has been an offline phase on our platform, because the courts have not been digitized, but now we're in this pilot with the courts in the Netherlands to also make filing through our platform possible. So that will come next year. This part will also be online digitized. So our process is that one of the 2 partners or ex-partners registers and picks a plan. This is either only a divorce plan or parenting and divorce plan, and they can opt for additional mediation, or they can also they can also opt for mediation later in the process. And then this initiator of the process, so to say, starts an online intake. And we have divided those in topics, of course, children, housing, assets, income, communication. And both parties answer those questions. And at the end of the intake, they see each other's answers to all of those questions, but only when they both complete the list. There's actually 3 types of questions. We have questions that are factual because we need it for the agreements, for the follow-up questions. Do you own a house, or is it a rental house, etc. But we also have an important category that we call the reflective questions. That are meant to create a mindset, but which are also important information later on for the case manager and the mediator and the lawyer to reflect on. And then we have a third set of questions, which we call the first idea questions. And those are closed answer options, because that's where our algorithm starts to work, because we match those answers between the 2 parties. And then and these are the types of questions, like, what's your first idea about what you're going to do with your owned house, for example. Do you want to sell it? Is one of you going to take over the mortgage, or do you have another idea? And what we do with those first answer questions, first idea question, we give back to the people how often their answers match and how often they are different. And it's all in Dutch here, the screenshot, because it's for Dutch, for our Dutch audience. But we give them back here. It's 10 times the ideas matched, and 5 times the ideas were different. And then we explain them that they get suggestion text templates of agreements that match their answers. And that is where they will start working on in the main part of our platform, which is visible here. On the left, you see all the topics that this particular case needs to make agreements on. So it mentions children with all the subtopics under the children. It's about housing, it's about assets, income, and communication. And in the center of the screen, there is this template that people now can start supplementing or adjusting with their own account. So they see what they have added or changed in the text, and they're working towards a complete text. And they are helped with this by targeted information on this particular topic, and also by the case manager, which I'll show later. But what their goal is to find agreement on each of these agreements and agree on the final version. So they're working towards 2 checked boxes per agreement. And the other work that they need to do on the platform is to collect all the documents that are needed. And we provide them also based on their situation with an automated personalized list of documents that they need to provide and upload in the system. And while doing that, the very central part of the platform, and this is shown on the left, is basically it's a timeline with chats between the parties, between the case manager and the parties, and additional experts that join this preparation phase if needed. We can, it's either the mediator that can join, or we have specialized alimony calculators or pension experts. They all can join the case and have this dialogue or this communication with the parties. So a lot of communication goes through messages, but there's always the opportunity to phone our case managers, and our case managers are available every working day and respond really quickly to these messages. And that is one of the things that our clients give back to us, that they are that they really appreciate the responsiveness or the quickness of the responses of the case managers. People understand that they cannot expect similar thing from a lawyer or a mediator because they are in meetings with other clients or in court. But there's often something on their mind that they want to have a quick answer to, or want to be reassured on, and then it's very comforting if the case manager can help them further. yeah, I did. What's also very central in our process, and I heard it in the discussion before with Darren Gingras, that people really need to be really want to know where in the process they are. So our timeline is very central to the platform. It's a personalized process, so it shows the steps this particular couple needs to go through, and it shows what they have already done and what they still can expect and where in the process they are. When they've gone through all the agreements and they agreed on them amongst themselves, the case manager does a thorough review through all these agreements and checks whether the file is complete, and then one of the lawyers from the network that we work with joins the same case. He or she is notified, and he or she enters the case and starts checking all the agreements and the documents online. And the lawyer's focus is to check the legal validity of the agreements, to check the informed consent, and check the balance of the agreements. That's the main task of the lawyer. So the reviewer also joins this chat functionality and starts talking with the party, starts asking questions, starts giving feedback to the agreements. The clients respond to that, typically make some adjustments, and then when the lawyer also agrees with all the final versions of the agreements, there's typically one meeting, either through online meeting or a physical meeting at the office of the lawyer, and then basically the documents are formalized and signed and submitted to court, and that part will be digitalized next year as well. And then the process basically ends, but we recently did add a aftercare module in order to enable people to evaluate the agreements, particularly the parenting plan agreements, and to update them when needed. The idea is that by stimulating them to evaluate them periodically, the conflicts can also be reduced. And either clients can make new agreements amongst themselves on the platform, or they can call upon assistance of a mediator or another expert that they need at that moment. And again, there's information about objective criteria around issues, and what we also have is a personalized checklist for the things that need to be arranged after the divorce. So that is very shortly how our process works. And basically it's an integrated dispute resolution process that goes through the stages of orientation and information, and then passes to dialogue. It has optional mediation or other types of support. We always have a review by a lawyer, and then a court decision, and after that, aftercare. So that's basically our standardized process, which is the backbone of our platform.
And Laura, typically, how long does this process take for a person to go from the beginning, the orientation and the information gathering, all the way through to getting the court to approve of that agreement?
Yes, well, that's an interesting question, because we don't have fixed time frames on this preparation phase of information gathering and dialogue. But typically, like on average, it would take 3 months to get to court.
Okay.
And then it's a couple of weeks before the decision comes back from court. But there is a large variety between individual cases. There are cases that go through the process in 2-3 weeks, and there are also couples who pace themselves and take half year up to a year. So it's also, it depends on what the clients want.
Okay, so it's truly self-paced, and it's up to the clients to determine how quickly or what issues they want to be addressed in that process.
Yes.
Okay, very good, very good. And then in terms of costs, is there an average cost that a couple could expect to incur going through this process?
Yes, we work with fixed prices,
Okay.
depending on the module that is needed. And on average, people would spend on a case. So the couple would spend 1,000 to 1,500 euros.
Okay. And I know that's kind of a big issue that we have here. You know, I'm in Texas, and I'm sure it's probably that way around the country. A lot of times couples are looking at, you know, hourly rates and retainers. Doing something on a fixed cost is probably very attractive to most people, particularly if they know that they can get everything that they need done all the way through without having to have an unexpected bill or cost at the end.
Yes. Yeah, and the reason why, because we pay our lawyers also a fixed fee.
Okay.
But the reason that that our lawyers are willing to accept the fixed fee is that we can guarantee that the work that needs to be done on the cases is within certain standards, so they know how many hours they still need to spend on the case.
Excellent, excellent. And Colin, I'm not sure, where are we on time?
Yeah, I mean, officially, we're at our closing time. I think we could take some questions. You know, if people need to leave, obviously that's great, but we'll continue to record this.
Okay.
Laura, would you be willing to take a couple questions?
Absolutely.
Okay. So does anyone have any questions that they would like to ask Laura, or comments they'd like to make about the whole discussion today? I see Darren is still on the line too. He might be able to answer as well. Let's just see if there's any questions. Okay, Richard, I see your hands up. What did you want to say? Oh, you're on mute, my friend.
Oh, yeah.
All right. Well, thank you for that presentation. I wonder if you do a complexity analysis during the intake, and I want to underscore what Darren said. In these family law cases, all human relations are highly complex. So, but we can do complexity analysis with respect to the level of conflict and the intensity of emotions in that conflict, as well as complexity and legal issues that come up based on the facts. So how does complexity analysis affect the way this model works?
Yes, well, that's a good question, and something that really has our attention a lot for obvious reasons. Once the couple, both ex-partners have answered the fairly extensive online intake. The case manager is the first person to review all the answers. And this is the complexity analysis, the first step in that. And we have protocols then to assess what the level of complexity is. And what often happens if there are issues, if there are red flags, then our case managers would call one of our lawyers, the collaborating lawyers, to make an assessment whether this case can go through in the standard manner or whether something else is needed. And a typical intervention would be to not wait with the lawyer phase till the couple has worked on all the agreements, but to suggest an earlier meeting with the lawyer. And our experience is that works very well in the expectation management of the clients. And then part of those complexity cases then are terminated on our platform in a way that our advice is to find support outside of our platform, for example, with one of our collaborating lawyers or mediators, or and another part can be dealt with on the platform, but perhaps with additional expert help, either on the conflict level or more on the legal complexity side.
Great. Darren, do you want to talk a little bit about complexity assessment?
Without a doubt, that's part of our triage process, and we put a lot of time into developing a triage process that breaks down not only the complexities of their file, whether or not there's pensions, whether or not they're self-employed, whether or not, but we're also looking for complexities as far as, mindsets. Are we willing to do this together? Is there a mindset of who's the initiator of a process? We're even down to, for instance, income, whether or not somebody has an income, somebody else doesn't have an income. And then really where we play from that point on. Again, you do have to realize we tend to target clients up to 5 years before they'll ever call us. That's really important you understand that. We're not trying to grab the clients that are needing a mediator today. We've been talking to them for 5 years. And in that 5 years, we've been assisting them with information geared at their complexities. So we're giving them information with regards to, this is what it means with regards to your mortgage. This is what it means with regards to parenting plans.
Great.
And then facilitating on legal processes from there.
Excellent. Excellent. I see there was a question from Emma for Laura about how often do couples elect to use mediator on your platform, Laura?
It's around 10% in our cases. So 90% doesn't make use of mediation, 10% does.
Okay, great. And maybe, Darren, this one's more for you from Ishigo. How do you strike a balance between using AI as a tool or fourth party to support clients and allowing them to exercise self-determination?
I mean, the reality, obviously, clients understand exactly what's involved with our process. It's a decision that they make when they choose us. Obviously, clients are made aware at every step. There is not a part of the process where there is actually literally a letter of engagement that doesn't go through and explain the next process. When you're being introduced to the next professional, when you're being introduced to your financial disclosure, there is a descriptive process, a document, a video that explains the next steps of what's involved.
Mm-hmm, mm-hmm. And Laura, this one's from Tammy. When an attorney reviews the case and provides feedback, are the parties, do they have to follow what the attorney says, or can they say, no, that we don't want to follow that?
Well, there's some minimum criteria, of course. There are, of course, legal standards when it comes to division of property, when it comes to alimony, when it comes to division of pension, for example, in the Netherlands. In a joint divorce setting, there is quite some room for parties to make their own agreements. But the importance is that people know what they are, for example, turning down in terms of if the division is unequal, for example. So a lot of the effort is put into, do you understand that you deviate from the legal standard? Have you thought about alternatives? Do you understand the consequences? And are there really no other reasons that you are now, for example, giving in than only kind of rational thoughts? So it's really about the discussion between the lawyers and the parties to make an assessment about their informed consent to not follow the legal standards, for example.
Great, great. Well, I know we are over, so I think we should wrap it there. I'd love to continue this conversation. It's just fascinating. I want to thank both Darren and Laura for presenting the great work that you're doing, and also to Anita and Tawana, thank you for your excellent questions and keeping the discussion moving along. And to Richard, my discussant as well. There's so much grist for the mill, and I think several people said there's a lot to think about. We certainly aren't going to get all the answers today, but it'll be interesting to collaborate moving forward. And Nancy, do you want to provide any closing remarks?
I just want to say thanks so much to all of our presenters, revealing what's happening in other parts of the world as well as in Texas. I am positive that there's a lot more conversation that could be had. I'm also aware that there are some people who tried to access today's program that weren't able to because we had reached capacity.
That's on me. That's my fault, not A&M's fault. It's my room, So I apologize for that, but we've recorded everything and we'll make it available.
And I also just, if there is anyone you've spoken with or who speaks with you and says, I tried to access it, but I couldn't, please be sure to let them know as well that the recording will be available to them. We're so excited at the level of interest in this. And I asked at the beginning, I'll ask again, those of you who think that there's some way in which Texas A&M could be especially helpful in Texas or elsewhere, please feel free to write me. You can find me through the website. And I also had posted my email address earlier. I'd be interested in your thoughts on how we can help with the appropriate use and development of dispute resolution generally and online dispute resolution in particular. So thank you.
Thank you, everyone.
Colin. Thank you to Colin.
Thank you. Keep up the good work.
Colin.
Keep in touch, and we'll see you at the next one of these.
Yeah.
Okay.
Thanks
Take
very
care.
much. Bye-bye.
Thank you.